This is the hearings session on energy and policy. Before we start, I'll just refer everybody back to the final agenda for the hearing session that was issued on the 13th of November, and I hope that everybody has received and has a copy to hand. Okay, thank you. Now there's some slightly different people here this afternoon, so I could just ask parties to introduce themselves, again starting off with the applicant.
Thank you, ma'am. Marcus Trinick, King's Counsel, instructed by Eversheds, Kirsty Smith. Doing all the talking virtually at the session will be David Bell, who sits to my left. Introduce yourself.
Thank you. Yes, David Bell, Chartered Town Planner, to cover the policy evidence for the applicant. Thank you.
Okay, and for the council?
It's James Finlay, King's Counsel, instructed by Highland Council. To my right sits Peter Whelan, who's a planning officer, who will be primarily dealing with the matters this afternoon, but it will at times be a joint effort.
Thank you. And then again for Glenurquhart Community Council, it's
Bill Smart, I'm Vice Chair of Glenurquhart Community Council.
And finally for Stag.
Good afternoon again, ma'am. Ian Kelly representing Stag.
Okay, could I just confirm, Mr. Kelly, that you are intending on taking part in the hearing session today?
Yes, ma'am. It is my intention to take part. I was going to say something. My comments might not be as full as they would have been otherwise. The last fortnight has been a bit of a distraction subsequent to the traffic accident that you are aware of, but I will do my best to answer the questions and contribute.
Thank you. Now, the purpose of this hearing session is for us to examine matters raised in relation to energy and planning policy. This will be a structured session led by us based on the agenda. There will be no formal presentations of cases or cross-examination. I will lead the discussion by starting off with each agenda item by directing a question at one of the parties. We may have some follow-up questions for that party, and then we'll invite the other parties to comment in turn. Again, we may have follow-up questions for those parties. The applicant will get an opportunity to make any final comments before we move on to the next matter. If you have any comments or questions, please direct them through us as the discussion progresses, but please also let the other party finish their point and not interrupt them. Now again, as with before, if you're referencing documents, please refer to the electronic page or paragraph number and provide document references clearly to allow other parties time to access the documents on the screen. And again, there's no need to say zeros when referring to documents. You can document numbers refer to as document 1.1 and so on. You will see us take notes, and we may have to pause discussion from time to time in order to catch up, so please bear with us as we go through this. And does anyone have any questions on this procedure? Okay, thank you. Mr. Finlay and Mr. Trinick, that you raised a point of clarification earlier.
Yes, it just related to the issue yesterday that arose about when Highland Council writing a letter in 2024 about 150-metre turbines. The impression may have been given that Highland Council hadn't raised the issue of scale or size of the turbines beforehand, but I think it's agreed that they had. My understanding is the concern that Mr. Walker sought to raise was that the specific suggestion of 150-metre turbines and their acceptability hadn't been raised at the previous meeting. Mr. Whelan, who attended that meeting, who sits to my right, has no clear recollection one way or the other whether it was raised, but he was the author of the letter that was written. So I think that the most I can say at this stage is that Highland Council would not consider it to be a false impression if it was left with you that they hadn't raised the issue of scale over a number of years leading up to that meeting. I don't want to go into the background of that, but and we leave open as to what was said at that meeting and don't challenge Mr. Walker's recollection being his clear recollection. and then I will deal with the contents of the letter and closing submission.
Have you got any points on that, Mr. Trinick?
I think the phrase is recollections vary. That if you look at the notes of the meeting, which is document 1132, and that was a June 24 meeting, the only reference to the vertical scale of the turbines is in paragraph 4C. So the cumulative picture is going to change, so should consider Loch Liath's horizontal vertical extent from Muir Feverney. Those notes were sent to Highland Council after the meeting, but no response was received. And then, and I say out of the blue, it was out of the blue, the letter arrived with the mention of 149.9 metre turbines. Those had not previously been mentioned as a possibility. So that did come out of the blue. That's all I want to say. Thank you. But I should add that Mr. Fenley was kind enough to brief me on this point last night, following which there have been conversations with the then project manager of Statcraft, who has no recollection of any mention to her after the meeting of that size of turbine, and Mr. Walker's also spoken to the EIA coordinator, who has no such recollection. Thank you.
Again, if I could just add a clarification to that, 150 or 49.9 metre turbines were expressly contemplated in 2020. In fact, it's in the document before the inquiry, document 1110. That doesn't go behind anything Mr. Trinick has said in respect of the particular meeting, and it's the difference between the parties concerns the recollections from that meeting, and and I don't think I need to say any more than that, but certainly at earlier stage, the possibility of effectively 150 metre turbines had been contemplated.
Thank you. Okay, so we'll start on now with item 2 on the agenda, and this is the Statement of Agreed Matters, which is document 11.8. I won't be going into the detail, but it's just to make sure you have the opportunity to open it up. And this question is to Glenairkirk Community Council and to Stag. And if you could confirm that you agree the points from the Statement of Agreed Matters as they were listed in the agenda.
Is that for us to answer? Is that your question or not? If we agree to all of these?
Yes, if you do.
Can we take them one by one? Or is it just general agreement on these? As we've got some statements on what you're asking.
If there's any of these specific ones that you don't agree with, these were the statements. This is the Statement of Agreed Matters that has been agreed between the applicant and the Highland Council. So it's a document from them rather than from the reporters. So if you don't agree with any of those points, if you could let me know, or let us all know.
In that case, yes, we'll agree to these. We'll come to quite a few in the course of the discussion as well. So that's agreed from Community Council.
And Mr. Kelly?
Stag were not signatories to this Statement of Agreed Matters, so I don't want to comment on the detail. What I can say is generally I'm happy to agree the points in the agenda, but with one caveat in relation to F and national development. my reading of NPF 4 is that the reference to national developments is to a type of development rather than specific Section 36 or planning applications.
Thank you. And just for clarification from both of you, with regard to H, NPF 4 should be read as a whole. Can I just check that you understand that when NPF 4 is being read as a whole, that includes the National Spatial Strategy, the policies, the national developments and their statements of need?
Yes, I understand that from the Council's point of view. Can I just add, though, that we're taking these as read, but we do have a point to make, in that we've said that the NPF Policy 4 is the key policy, but I believe that Policy 3 and 5 are relevant as well. Or we do, rather than me.
Thank you. We will be moving on to policies 3, 4 and 5 later on in the agenda, so we'll pick up the points then. Thank you. And Mr. Stagg? Mr. Kelly, sorry.
Yes, I understand the concept that NPF 4 should be read as a whole, and I'm content with that.
Okay, could I just check with other parties, with Mr. Finlay, have you got any comments on that point, or these points?
I don't have any comments from the council side.
Mr. Trinick?
Nothing more, thank you.
Thank you. So moving on to agenda item 3 and need. There's a number of documents that are before us that set out capacity figures, and these ones that we have identified, I can read you the list of the documents. I'm not necessarily asking everybody to read them, but it's just if people want to refer to them, then we have them. We have the Stag's evidence on capacity, that's document 14.2. In your hearing statement. Document Document 7.1 and 7.27, which was newly submitted, Draft Climate Change Plan 2026-2040. Then documents 11.3, 7.14, 11.47, 11.48 and 11.49. And the questions, first of all, to you, Mr. Kelly. As discussed in your hearing statement, are all the capacity figures acceptable, and what should the reporters take from these?
I'm not sure what you mean by the word acceptable. I mean, what I have set out is factual information from the Scottish Government. What I would say is that it's important that in your consideration you bear in mind the installed capacity, the consented capacity and demand in Scotland, and take these figures into account. I mean, obviously you may reach different conclusions from me, but my key point is that you should have regard to these figures and not just ignore them.
Mr. Kelly, can I just ask what capacity figure are you putting most weight on? Is it the 20 gigawatts by 2030?
No, what I'm looking at is the demand in Scotland. Current peak demand is less than 5 gigawatts, and at the moment we have 10.4 gigawatts installed onshore wind capacity. And the total current installed capacity in Scotland is 17.7 gigawatts. So my approach is to compare these figures with demand.
Thank you. Could I just then direct to Mr. Bell? Again, in terms of these capacity figures and need figures, again, which ones do you think should have more weight, or that we should have take account of?
That's fine, thank you. I would say the key figures for you to focus in on are, there's a few documents, source documents on them. Firstly, the onshore wind Scotland target for 2030, 20 gigawatts, which is in 7.4, I've got that as, maybe that was your document, 7.1. Onshore wind policy statement. And there is then the UK onshore wind 2030 target, which is 27 to 29 gigawatts in the Clean Power Action Plan, which is 714. And the point about these targets are they're not caps. And 2030 is a stepping stone on the way to net zero at 2045. So it's only part of the way to net zero. And I think the most recent position on capacity and emission reduction would be in two documents. One is the Scotland's carbon budget, which is 1148, which is the Climate Change Committee report to the Scottish Government in May this year, which has been followed up very recently by the Draft Climate Change Plan, which is 727, I've got that as. And the Climate Change Plan fully accepts all the Climate Change Committee's advice. And before going to the Climate Change Plan briefly, it's worth just looking at the figures in the CCC report. So I'll take it fairly briefly, but given it's the most recent document, it is one of the most important ones, I would say. On page 8, sorry, I just dropped my pen there. Got it. On page 8 of the CCC report, it sets out the recommended carbon budgets going up to net zero, and you can see the 4 bullet points there setting those out. And at the top of the following page, page 9, it says getting to net zero by 2045 will require immediate action at pace and scale. And that maybe relates to one of your other questions about pausing, whether we should pause now. But the CCC's advice is, look, immediate action, we need to move at pace and at scale. And on page 10, it sets out that Scotland has been very successful about phasing out electricity supply carbon, but the key section is on page 12 under electricity, where it sets out that low carbon, this is the first bullet, low carbon supply in our pathway. I should say the pathway is called the balanced pathway, which was set out in the UK carbon budget. That's the 7th carbon budget, which I make reference to in my hearing statement. So this is the more granular advice for Scotland from the CCC on the balanced pathway. And it states that in the pathway, the capacity of renewables in Scotland, including onshore and offshore wind and solar, more than triples from 15 gigawatts in 2023 to 49 in 2035, increasing to 66 gigawatts by 2045. So, at the moment, Scotland has about 17 gigawatts. Mr. Kelly is correct. That's overall renewable capacity. That's onshore wind, offshore, but also hydro. So what the Climate Change Committee is saying is that to achieve the emissions reduction by net zero, Scotland needs to have in place 66 gigawatts of low carbon renewable supply. And then the following bullets explain the sectors where there really needs to be substantive progress, because the electricity decarbonisation is largely done with Mackenzie Way, Longanet, and a lot of renewables already on the system. And Mr. Kelly referenced meeting demand is not about just current demand, it's about the anticipated demand that will come about from electrification. And the CC sets it out by, the next bullet is electric vehicles by 2035. 3/5 of cars and vans will be fully electric, and it goes on then to net zero. Then the next bullet is heat pumps. By 2035, 40% of existing homes will have electric systems, so moving away from gas boilers and having that deep electrification through buildings. And then the last bullet is about industrial electrification by 2035. So just for example, I'm working at the moment on Sullom in Shetland, where there will be a wind farm powering the synthetic fuels that will go into industrial plants and for heavy vehicle electrification. So that's where there needs to be real progress, and that's why the 66 gigawatt figure is a large one. So come back to the point about 2030. Yes, it's important as a staging point in the journey to net zero by 2045, but it's not the overall focus. The overall focus is 2045, and then how do you sustain those figures? And just to round it off, the draft climate change plan, which came out very recently, sets out the emissions reduction pathway through 4 carbon budgets, and also on page 11 sets out the economic opportunities for the just transition, and the first key opportunity area is wind energy on page 11. So it's the government, I would say, being very consistent about, it's looking ahead to 2045. Wind is a key component. It's not the only technology, but it's the lowest cost key technology for this decade and beyond. Just to finish off, I would say that in my hearing statement on the sort of wider context to this, the 7th carbon budget, I refer to that on pages 8 and 9 of my hearing statement. And there's a graph in there on page 9 of my hearing statement, which shows the trajectory of onshore wind in the balanced pathway. So this is now looking at the UK context, and you can see that it goes almost up to 40 gigawatts of wind by 2050. Almost up to 40 gigawatts of wind by 2050. And at the moment, the UK onshore wind capacity is 16 gigawatts. That's the UK position. So what the Climate Change Committee is saying, in the pathway, they're looking at a figure of 37 gigawatts. So there is a shortfall there against the pathway that the government has signed up to. So I think I'll draw a halt there, but these are out to the latest target figures and source documents for you. Thank you.
Thank you, Mr. Bell. Mr. Finlay or Mr. Whelan?
Hard to follow that. A lot of what Mr. Bell sets out was essentially what I'd written down in terms of my position, up until the point where he got into the more recent documents. And to be fair, these aspirational targets are exactly that. These are draft documents. That is the future that the UK government has signed up to. I feel that Highland has taken on a very large share of renewable energy development for not just Scotland, but looking wider than that now across the UK. I think we're responsible for roughly 30% of onshore wind at present. Now, in terms of our approach to onshore wind, we're very favourable as a council, and that's reflected in our Highland Wind Local Development Plan, which is then obviously predated MPF4 by a number of years, and we're very familiar with this type of technology and what challenges that poses. In terms of David's point about cost, it's got an important point that the UK policy is essentially low-cost energy, but it's land-hungry, and that comes at a long-term legacy cost as well.
Thank you. Mr. Kelly, do you have any comments to make on the points raised?
Nothing further to add, ma'am. Thank you.
Thank you. Mr. Bell, any final comments?
Just a couple of things. I was just going to say your question had the timescale of development in it, and this project has a grid connection date that would be post 2030, but there is connection reform underway at the moment for the overall GB grid, and the applicant has requested that the grid date be brought forward to 2031. But the NESO, that's the National Energy System Operator, will not be revealing to any developer in Scotland what their position in the grid queue is until March 2026. But the applicant is guaranteed a connection because they had their application in before December 2024, which was the cut-off date for the grid reform applications. So what I would say is that, notwithstanding the connection date would be post-2030, that wouldn't diminish the weight to be attributed to the benefits. Because of what I've set out, that 2030 is a staging post, if you like, on the way, and clearly capacity needs to be sustained as some projects will perhaps come offline before then. And the last thing I would say about the scale of development, it's over 50 megawatts, it's a national development. The applicant did also look at, if the scheme was to be 149 to tip height, then the rated capacity of the turbine would be lower. It would be around 4.5 megawatts probably, which would be a 58 megawatt scheme as opposed to what it is currently, which is 85. And the energy production, or the yield, at 149 metres would be reduced by some 33 to 36%. So I appreciate that's not in the written evidence, but given there had been some discussion about tip height reduction, if that was to be the case, then there would be a resultant reduction in the energy yield that the development would provide.
Thank you.
Okay. Just a quick question. So I guess it wouldn't make a contribution to that 2030 target, but given the trajectory between now and looking at the other targets that come out of the carbon plan, it would make a contribution to those targets where the trajectory is kind of steeper.
Yeah, I suppose if the 20 gigawatts isn't achieved by 2030, it would still make a contribution to that notional target. But strictly speaking, you're right, yes, it would contribute post that period to Scotland's supply requirement in the post-2030 period.
Thank you. Sorry, Mr. Smart. I should have called on you before. Have you got any comments?
Yes, I have a couple of comments on this. The Climate Change Committee, the recent report, and you said they told the government to move at pace. That's referring more to the need for energy to provide heat in homes, and they were looking at what needs done there, because I think, and you can correct me if I'm wrong in this, that actually the benefits from rushing the development of wind farms and reducing the carbon budget has slowed down, and that they need to now speed up to make big improvements on looking at housing, better insulation and reducing the use of energy for heating. Is that correct?
I think these are very fair points. That's where I think Scotland has struggled to make inroads into low carbon housing. Mr. Whelan maybe knows from the Council's efforts on their role as planning authority for new housing planning permissions. It will be a matter that planners, not just in Highland but across Scotland, will be trying to drive forward where they can. But it has been challenging, and I think what the CCC have done is flag up that these are the difficult areas that need to be given attention now, and that comes through in the climate change plan, and that is a key issue. Yes.
Thank you for that. That's where the difficulties are. I think we have difficulties with the rush being implied to keep going at pace with wind farms, in that, one, the grid can't take it, and there's constraints on that, and B6 on the borders doesn't look like being resolved anytime soon by Scottish Power, whereby that would open up the line that would take the power, the extra power that Scotland doesn't need when the wind's blowing down south. But at the moment, NISA will come back. They've got a lot to look at. I mean, they have problems with the control systems, for one, and that they haven't got a smart system yet, which will look at alternatives other than firing up gas stations when the wind's been abated. There's too much of it, and they can't put it into the system. So I think focusing on the fact that there's a rush to put in wind farms, we'll really need to wait until NISA have got their heads around how they're going to control the grid system to improve it, so as we don't burn gas when you have to switch the wind farms off, which is happening at the moment. Those gas stations are largely unabated. They don't have carbon capture storage on them, so that's a problem in its own. And also, I mean, at the moment they're looking at installing further gas turbines under 300 megawatts, which only need to be CCS ready. They don't need to actually put it in. So I think there's a bigger picture to be looked at.
So, Mr. Smart, would you accept that wind energy plays a part in the overall picture of reducing fossil fuel, meeting these targets from the Climate Change Committee, that wind farm development will play a part in that? Do you accept that wind farm development will play a part in meeting these budgets, carbon budgets, set by the Climate Change Committee?
Yes, they will help these targets, but it's one thing to say do this, but if you can't put the electricity generated into the system, and there's no firm dates yet as to when they would actually, there's an obligation for them to connect this system to the grid if it gets the go-ahead, but whether or not you can actually use the energy it can produce is another thing. So yes, it'll help reduce the targets if all the grid systems are in place to actually harness that energy properly without it effectively being wasted, and we can reduce the need for using gas turbines to cope with the fluctuations in the grid system. Does that answer?
Yeah, so it's kind of a timing issue, trying it
Yes, it is a timing
the
issue.
grid sorted out to allow these issues
Correct,
to be
yes.
bottom out, and then think about how we generate the electricity to get into that grid.
Yes.
Just had a couple of points. I think you're absolutely right in your characterisation of the issues. It's not a perfect world at the moment, but what NISO is doing is increasing grid infrastructure in the UK, but also energy storage to help balance out the system to avoid too much gas coming online. And in Scotland, the strategic transmission infrastructure applications are in and running. Section 37 applications from Spittal to Bewley, Bewley to Kintore, Kintore to Teeling, plus other reinforcements and others within the Scottish Power area. But they're not all in place yet. And the government's approach isn't to say, look, let's stop and wait till we get all that in place. They are doing grid reform at the same time with the queue system, so that projects that are consented and ready to go can come online to meet the Clean Power Action Plan objectives. So I would just say you're correct, but there are actions underway, but it wouldn't be for this inquiry to resolve all of those or change the approach. Thank you.
Yes, it's interesting you talk about storage there as well, though, and that you look at pump storage that they're working on at the moment. But given that, as Mr. Kelly said, Scotland at a peak at the moment needs 5 gigawatts. England is about between 50 and 55 gigawatts instant. If it needs it, that can't necessarily be provided by wind farms. It would come from other interconnectors, gas stations, nuclear, hydro, and pump storage if that gets built as well. So in this rush, this is what I'm saying, the balance needs to be that we don't waste the energy we're trying to produce. Yes, we can put these wind farms in, but there again we need to store it, and the storage capacity in the UK is very low, and that should be focused on going forward. And what is annoying is to see these reports coming through and say, yes, get the renewables in, but can you store that amount of capacity? I mean, 55 gigawatts of storage, take it to 60 to 70s, a lot of storage, which requires, yes, they've got batteries, but then they need to be integrated into the system, which NISO will look at, but that's way behind and being pushed forward. So yes, we do need the renewables. We do need to be looking at building wind farms to give us that capacity when we can use it properly. But I think there's an awful lot of other things need to be done before you say this project needs to definitely go ahead. Maybe you can have it ready on the desk, on the table, but is it right to say, yes, build it and run it?
Nothing further, thank you.
Thank you. Just moving on to the point B, and Mr. Kelly suggested that there's no over provision, but I'd also like to take people to page 16 of Mr. Bell's hearing statement, electronic page 17, and it's table 2.2, where there's information about the status of onshore wind projects. And there was a mention earlier from somebody about whether wind farm developments will continue to operate. I suppose the question really is there an over provision if there's capacity from operational, under construction, consented wind farms, or should we consider or take into account if there's existing operating wind farms that may come offline in the future? I think first of all to Mr. Kelly.
I'm not really sure you can take account of wind farms coming offline in the future. My position is as set out in the inquiry report, is quite simple, and that is that there's currently an over-provision compared to demand, and that's a simple position.
Thank you. Mr Bell?
The applicant's position is there is no over provision, as just explained for over the last 10 minutes. And the demand picture is ever changing, and we saw the trajectory of anticipated demand going out to 2045. And we've been over the figures, so nothing further to add to that. Thank you.
Thank you, Mr Whelan.
Yeah, just a general observation. The strategic lead for the council's strategic projects team, if you like. So, at the moment, we have multiple wind farms consented, sitting on people's desks, and the decisions are not being made to build those out at the moment. Part of that decision is related to the grid. So, as Mr Bell points out, the ASTI project framework is with us. We have 4 substantial substations that are pending consideration at the moment. We have the Spittal to Carney to Bewley 400 kV overhead line. We also have the Bewley connection going out to Aberdeenshire as well. That's just in the north of Scotland in terms of the grid upgrades that are required. Billions and billions of investment that needs to take place. It's the first time I've heard that the actual timescale for delivery of this project is actually beyond 2030. It's not a surprise, but it's the first time today that I've heard that. I just caution then in that context, actually having a stockpile of wind farm consents doesn't actually do anyone any favours. What happens is you have time limited consents that then need reworked, repowered. There's additional resource that's going in to effectively give investors confidence about the estates and the options they've got on those estates to take those sites forward. It's reverse engineering. You want to have the grid system designed first. You should have the NASO plan in play first. But I accept that given the policy framework we've got to work with, the lack of an overarching strategic plan is, we don't have that luxury. We have to accept hard decisions here and now. I would just be cautious that we make the right decisions. And as a council, we try to do that as a team, and we often recommend support for proposals that we think demonstrate best conformity with the development plan as a whole and all those targets that are set by government.
Ma'am, can I just jump in to, if you don't mind, to clarify one point from what Mr Whelan's just said, and that is just to say that the council has objected to the Spittal to Loch Liath to Bewley overhead line, so that will be going to a public inquiry, so there'll be no decision there in the near future on that. Thank you.
Thank you.
I can just clarify that is the case. The application is yet to be reported to our committee members, but officers have given an objection to that overhead line. If you want to go and read it, it's 8 pages long, and it's quite laborious, and there's a lot of statutory consultee objections to the design of what they have come forward with in terms of the routing, and not for today, but it just demonstrates the difficulty we have of moving the energy from the north of Scotland to where it needs to be consumed in the south of England.
Mr Wayne, sorry, just to clarify, do you think there is over provision because you've got the stockpiling of consents that haven't been built out?
To be honest, at some point we're going to have to see these sites delivered, and the figures demonstrate that we're going to need a doubling of onshore wind at least within the short time frame. We're seeing rapid escalation of battery applications all over Highland to try and build that extra resource that's also needed alongside the grid upgrades. We don't know yet if it's over provision. It depends how much will be transmitted, if you like, and how much will be converted to hydrogen. It depends on how good the batteries are going to be, how many pumped hydro schemes are going to be built. There's lots of uncertainty.
Just going to add that the grid reform gave rise last year to a lot of uncertainty, and given there to be reapplications for grid, there was a pause on investment decisions. With that, we should get more certainty on that next spring. Also, we have the UK government changed last year, and they've brought in contracts for difference for onshore wind. So that will provide more confidence for investors. And on looking at this particular project, assuming the consent was forthcoming, then looking at the elections next year, and it may be later in 2026 until there is a decision. If the grid date of 2031 does get confirmed, then once you start building in timescales for discharging conditions, procurement contracts, and so on, you're not that far off 2031. So I don't think it's an unusually lengthy period such that you would need to apply caution to that. But I do appreciate Mr. Whelan's point about these wider issues that have given rise perhaps to a hiatus of some site starts going ahead on that. Thank you.
Mr. Smart.
As I said before, I mean, you look at the balance that's required here, the over-provision of it. I mean, Scotland needing 5 gigawatts. We've got 17.7 gigawatts available at the moment. You do arithmetic on that, that means it's going to be exported, but it needs a pipeline to get that down to where it's needed. But I agree with everybody in this. I mean, if these wind farms coming forward, there's no point in them trying to build them now or in the next few years until they can actually connect up to the grid properly and it can be harnessed properly. And it'll be interesting to see what NISO will come up with in 2026 on their policies.
Thank you. Just moving on to C, and given that National Development 3, which renewable energy forms part of, so given National Development 3 in the NPF 4 includes a statement of need for renewable energy generation, does need require to be demonstrated for this proposal? So first of all, to the applicant, Mr. Bell.
Thank you. In principle, it doesn't need to be demonstrated because of the statement of need, but often the need case is challenged, as it has been at this inquiry, not by the Council. The Council has taken a fair position on that, but it is necessary to respond to the other parties' positions. But I also think the NPF4 was February 2023. There are new need material considerations in place which you've been able to look at through this inquiry, and they have been pointed out so far. Thank you.
Thank you. Mr. Whelan?
Yeah, I don't think there is. There's no need. Essentially, there is a need, and it cannot be disputed that there is a need. How much weight you attribute to that need is the key question.
And just to follow up, does the key question really become about the location of the facilities and consideration of environmental factors of proposals?
I think that's fair, and it's then looking at the criteria, particularly in Policy 11, which we'll come on to, and then the contribution to targets element of that policy that appears at the end of the policy wording, and that's where what we've discussed this morning would come into play when balancing the adverse effects against the benefits.
Thank you, Mr. Whelan.
I would agree.
Mr. Smart, have you any comments on that?
No, I've no further comments other than we may come into this again in Policy 5.
Thank you. And Mr. Kelly?
Basically, actually, I agree with Mr. Bell's earlier comment to the effect that need is a dynamic concept that is changing over time. So you do need to address it. You will reach your own conclusions, but you do need to consider this aspect.
Mr. Bell, any final comments on that?
Nothing further, thank you.
Okay, thank you. So we'll move on to agenda item 4, titled Policy Considerations, and 4A. This is in reference to the Scottish Government's Draft Energy Strategy and Just Transition Plan, document 7.5. And my question, first of all, to Mr. Bell, is what weight should be given to this?
Thank you. I would just take the long-standing approach in planning practice of placing relatively limited weight on a draft document because it could be subject to change. It does, however, reiterate the government's net zero target. It refers to the 2030 onshore wind minimum target. But these factors are also in other documents before you. So I would say limited weight, but it remains an important document.
Mr. Whelan?
I would concur with that.
Mr. Smart, have you any comments?
No, I agree with that as well.
Okay, thank you. Mr. Kelly?
I agree too, ma'am.
Thank you. So on to 4B of the agenda, and I suppose it's bringing together some of the discussion that we've just had, but as suggested by Mr. Kelly in your hearing statement, paragraph 64, should the decision on the development be deferred until the UK Government has published its proposed strategy, spatial plan for energy infrastructure, and or until these other documents will be published for Scotland. So first of all, Mr. Bell.
Thank you. The strategic spatial energy plan may not be published until the end of 2026. That's NISO's position on it. I would say there's no requirement or need to assist or pause any planning determinations or Section 36 determinations until that is in place. Perhaps in an ideal world if there was time, but at the moment, you know, the report we looked at earlier, the Climate Change Committee report, page 18, states we're only 20 years away now from 2045. It is time for the government to take action, cut bills, drive emission reduction, and then, so the reference there is to immediate action in that paragraph after it says 2045 in that last paragraph. So the government's position is not let's pause and wait and see, it's take action now, and that also comes through in other documents. The onshore wind policy statement makes reference to going further and faster than before, at paragraph 1.1.2, in light of the increasing electricity demand that there's likely to be. So the applicant's position is no justification to pause now until these documents are published, perhaps in 12 months' time. Thank you.
there's no need to pause. I accept it would be highly advantageous to do so from a planning perspective, to have a spatial plan in play and published before decisions on the generation, locations and form come forward. As a result, we're going to have to retrofit around consents, and that may well result in additional expense and duplication of effort and disruption as well to communities where schemes will be built out in an ad hoc, potentially unplanned manner in relation to what might be required. But decisions must be made based on the best information that we have available today, and that's the approach we've taken as a council on other wind farm schemes as well. The climate emergency is now, the decisions have to be taken, and our position is that we are positively determining better design than sited wind farms and what you've seen today.
Thank you, Mr. Smart.
I agree on that. I don't think there's any need to defer.
Thank you. And Mr. Kelly.
Thank you, ma'am. Given the realistic timelines for grid upgrades, I do think we can take the opportunity to pause for just 1 year to get a better decision-making framework in place.
I suppose, would you accept there's maybe consequences of delaying, or do you think there are consequences of delaying?
Sorry, ma'am, was that directed to me?
Sorry, yes, it was.
No, having regard to the position with the grid, I don't think there'd be any adverse consequences from a 1 year delay.
Just in response, I think there would be a massive impact on investor confidence. There would be a substantial impact on construction activity and the resultant direct, indirect, induced economic benefits that would be lost, not just in Highland but in the rest of Scotland. The supply chain would be hit substantially. So there's a range of negative impacts, but more importantly, there would be 1 year less on that time frame that the CCC has flagged up. Is very tight already. Thank you.
And assuming your best guess of when these might come out is just an estimate at this point, and that could slip.
I think ESO have been quite generous with their timescales later in 2026, but you know, there is a lot of pressure on them to deliver. For part of that will be about achieving 2030 and then looking beyond it. So the mission control that the Westminster Department has got in place is putting pressure on for that to be delivered. So I would be surprised if that does slip, because it then puts the Clean Power Action Plan objectives in severe jeopardy, and that's a key plank of the Westminster Government's mission at the moment. Thank you.
And could I just ask Mr. Kelly, with the suggestion for pausing the decisions on the proposal for 1 year, would that be a suggestion that the project, as it stands now, would just be put on hold? Or would you suggest that other things would need to be taken into account to reflect a 1 year pause?
The application that's in front of you would just be put on, the decision on the application in front of you would be put on hold. Can I also just respond to what Mr. Bell said? During this 1 year pause, there would be nothing to stop wind farms that are already consented from proceeding to implementation, so there should be no real effect on supply chains or jobs.
Thank you. Mr Bell, any comments?
Nothing further, thank you.
Thank you. I think we've covered agenda item 5A, the socio-economic benefits. So I would move on to 5B and the question of whether the contribution would be a nationally important contribution, which is the applicant's position, a meaningful contribution, which is the council's position, or they would make little or no contribution, which is Stag's position. And this is in relation to, I think, meeting the energy targets. So first of all, to the applicant.
Thank you. The project would be nationally important. That's the applicant's position. And our position is it would make a valuable contribution to targets and as such should be afforded significant weight. Thank you.
Could I just check, so the valuable contribution is there quantification in terms of, is valuable or is nationally important?
That's the language the Scottish ministers tend to use in their decisions. We'll come on to one with one of the other questions. So I think that would be consistent with the way ministers have approached large-scale Section 36 project, is to afford significant weight and reference it as a valuable contribution to emission reduction targets. To give you an example, Census, which is the recent consent by the Ministers for a project on the Western Isles, which is document 11.034, paragraph 116. That's where they make that reference on a valuable contribution. Thank you.
And Mr Whelan, your comments?
Yeah, I think we're sticking with the position that it's a meaningful contribution. I haven't found anything in policy terms that sets out what a national contribution means. Just because it's a national development doesn't necessarily correlate to be a national contribution. It may seem a bit pedantic, but it was a point that I was keen not to agree to when set out in the agreed matters, because it wasn't agreed. So, unless Mr Bell can point to the report referring it to as a national contribution.
No, I think meaningful and valuable, pretty similar. I think in terms of the level of contribution, I don't dispute there was a difference in the two terms. Thank you.
That was going to be my follow-up question. Mr Whelan, is there a difference between valuable and meaningful?
Potentially just putting more emphasis on the importance of the development going ahead is my take on what had been drafted. So my position is that it has no relevance to the determination of the application whatsoever and the application of policy. What is more material is obviously its generating capacity, and if that generation will then be effective or if it will be constrained, then that's a factor we've discussed.
Mr Smart, have you got any comments on this?
Yes, it's really just on the national importance of this, and that now we have a new government that lifted the ban on wind farms down in England. There will be wind farm developments coming forward there. You could look and say, yes, it's got a contribution nationally, but we have an abundance of wind farms up here at present, and looking at the context that we've been looking at today on other landscapes and visual. Is there a necessity for it to be built here, when in fact it could be built south of the border? There would be nothing stopping a similar wind farm down there, so a better site down there, and it would be near the source. It would have bypassed all the blockages that we're facing on the grid. So whether it's nationally important, I think it's debatable.
And Mr. Kelly.
What was in my mind here was that it will only make a contribution if it's consented, built, transmitting electricity to the grid, and that electricity getting to the market. And I think there's considerable uncertainties around the latter parts of that. Thank you.
Just to finish off on that, policy 11 NPF 4, second last paragraph, grid capacity should not constrain renewable energy development. So I think Mr. Kelly is right, the benefits would only be realised with that connection, but national policy tells us for decision making that should not be a factor. Thank you.
I just have a further question about his contributions towards the renewable energy targets, and it's to do with the carbon calculator and payback terms, and whether the savings take into account, the carbon calculator savings or the carbon savings take into account overall losses of 96,000 tonnes CO2 is mainly due to non-site losses, including provision of backup power to the grid and ecological carbon loss. Just all of those things, have those been taken into consideration and taken into account when determining the type of contribution that the proposal could make?
The carbon calculator has been used, and that does have reference to assumptions on manufacture and so on. And it's perhaps not a perfect tool, but it is the best means available at the moment. Just to give you a reference to that, in the census consent, I referenced the same paragraph, actually, paragraph 116. The Scottish Minister states on the carbon calculator, whilst noting the limitations of any such calculations, the online carbon calculator provides the best available means by which carbon calculations can be provided in a consistent and comparable format. So the government's taken the view through the statement of need in NPF 4, it wants to deploy onshore wind and other renewables. The carbon calculator is just one tool in allowing the ministers to compare the benefits of projects and to look at key carbon metrics. So I don't know the absolute details of the carbon calculator, but it is within the EIA report, and all the assumptions have been set out in the technical appendix on it. It's been done to the satisfaction of SEPA, and as the ministers have set out in that very recent decision, it's the best available means at the moment. It may be improved in the future, but you know, that is what we have to work with.
And I guess from a decision maker's perspective, it's a comparative tool. So even though it's got some shortcomings, if it's used by everyone, you can get comparison that's the same. You're comparing apples and apples rather than apples and pears.
Correct. Yeah. The ministers do, in their decisions, you'll have seen, refer to carbon savings principally in CO2 tonnages, and that information is there for this application.
Just moving on down to 5C, what weight should we give to the predicted carbon saving?
I think the the onshore wind policy statement is very helpful in that it tells us that at the end that onshore wind is critical to statutory emission reduction targets. It says onshore wind is mission critical for meeting our climate targets. That's page 49, and again in that paragraph in new census, the Scottish ministers state this: they're satisfied the development would provide carbon savings, and are satisfied it would make a valuable contribution to Scotland's renewable energy, electricity and emissions reduction targets, which should be accorded significant weight in favour of the proposal. So I would say, being consistent with that, significant weight.
Thank you. Mr. Whelan?
Yes, some of the points have been made, but essentially there's no other calculator available at present. I think industry had mooted that a new calculator was in preparation. It's gone very quiet, and I'm not sure if there's been any updates since then. One thing that I would pick up on is, having looked closely at the grid-related requirements for the 400 kV line, the size of the substations, the footprints, the size of the transmission towers, the extensive tracks that are going to be required to facilitate that. Only one of the substations have put forward any CO2 balanced assessment to show what the losses will be, and that's essentially because the substation is impacting upon a huge area of peat, and effectively the policy then requires them to demonstrate what the carbon emissions will be as a result of developing in that location. But no other aspect of grid gives you accountability of what the CO2 emissions is for that project, where the components are constructed, how far they're being transported. I'd assume that I don't know precisely the date of the calculator and what infrastructure it envisaged in terms of transmission, if it done it on a basis of looking at grid at that point in time and how much carbon was required for that. Effectively, the grid, when it gets back to the balancing exercise of how they're going to offset this, they point to the renewables industry and say, well, they're going to pay it back for us, so don't worry. There's no checks and balances. The figures presented are the figures based on what's put into a calculator that's available at the present time. The fact is they're using infrastructure on site brings their payback period down, so the fact that they're using an existing access track on the neighbouring estate is a positive factor, and I think that demands consideration. But that's about as far as it goes. I see a number of these figures that come across my desk, and the lower ones are essentially the ones with the least access track getting into the sites. So for comparative purposes, and obviously the lower ones are obviously the ones where they've carefully cited around the deep areas of peat as well on site. But as far as the tool goes for determination how much weight should be attributed to it, it's very crude. And I would say that looking at the generating capacity of what's actually going in is far more effective than the carbon balance assessment is actually telling you.
Just to finish off, I do acknowledge that the project-specific issues, and in particular where you're dealing with perhaps non-wind farm development and the carbon issues that Council needs to deal with there and perhaps judge. But I would say that for this strategic renewable project, which is part of National Development 3, the government has looked at life cycle greenhouse gas emissions. So on page 103 of my version, which is the revised draft NPF4, which I think it might just be one page out on your final version, but it's under the statement of need where there's a subheading life cycle greenhouse gas emissions assessment. And it does say there that depending on the nature of the projects, the life cycle greenhouse gas emissions assessment concludes that this development, i.e. National Development 3, will likely have an overall net positive impact on achieving national greenhouse gas emissions reduction targets. So I think the government is recognising probably that, look, there will be some projects that may involve some CO2 creation, but on balance overall it's going to be net positive. And it's not just the Scottish Government, it's a worldwide consensus probably that renewable energy is the way forward, with most countries buying into that and seeing that that is the way in which to deal with climate change. So that there is a check and balance in NPF4, where the government's checked it before it embarked on the policy. We're now dealing with the policy, and the carbon calculator is part of that toolkit to inform decision makers. But I do agree, you know, there's room for improvement, and I think it is being looked at.
Thank you. Mr. Smart, it was the Community Council that raised comments in your consultation responses about the carbon calculator and whether it was fit for purpose. Have you got anything else to add on that or that's been discussed here?
Yes, I have. Just some information on the present calculator. It was developed in 2008. It's not undergone any major revisions since 2014, despite substantial advances in peatland science and life cycle carbon assessment methodologies. The current version fails to reflect updated emission factors and whole life carbon approaches. I believe that the Scottish Minister has appointed an expert panel. It's met several times, but they've come to the conclusion in the latest minutes that it's not fit for purpose. And really in that, there's a lack of data on the effectiveness of mitigation and restoration, get the right word, restoration projects, and these present estimations can't be justified. And I mean, there's experts from various bodies and universities have serious concerns over these carbon saving estimates being reliable at all. And when you take, for instance, in this particular project, the damage to the peat area from 9 kilometres of road, 2 kilometres of it being a floating road, could be 250 metres either side of it. And then you've got to look at the whole peat bog will gradually dry out over the years. So, you know, you're looking, they've said, I think in the report that the carbon saving says it will be saved in 2 years. I find that, from what I've seen now, it would be impossible to predict.
And just to probably reiterate that the carbon calculator has made predictions based on assumptions within the model. The mitigation hierarchy has also been applied, as set out in the EIA report. We'll come on to that in a later question. With all the soils and peat mitigation actions in there to the satisfaction of SEPA and the council. So whilst there is an impact, it has been mitigated appropriately and hasn't been raised as an issue by consultees.
Just on that, I think we might come on to it later, is that the Blae wind farm enabling works, the roads that were put in there, I mean, I was involved in looking at that as part of the community council meetings. SSE even themselves admitted it was a mess. I don't know how you can go back and look at how you stop that happening again, but actually we're entering another area which is even more sensitive than the Blae wind farm extension. And I know part of the mitigation measures is to look at competent contractors that will be in the conditions, which we're going to look at as well later. But it's just how you ensure that that doesn't happen again in this particular development, given that we're entering an area which has a deeper peat in it of national importance.
Mr. Smart, do you accept that there's no other alternative calculator? We've kind of got what we've got.
At present, yes. I mean, it's not fit for purpose. The people looking at it are saying that. And given of what we're trying to do with this development, we've got the facts in front of us of what we're entering into. And if they've said it's not fit for purpose, what other, how are you going to apply a carbon calculator to it?
So do you think we should give it less weight because it's not fit for purpose, and balance and put it into the balance of all the factors we've got to balance and put it on the side of less weight?
Yes, it should carry less weight, yes.
Thank you. Mr. Kelly, have you any comments?
No further comments, ma'am.
Thank you. Mr. Bell, have you got any final comments on this?
Nothing further, thank you.
Okay, thank you. So moving on, there's been some discussion, this is 5D, about connections to the grid. Should benefits associated with construction of the grid connection be discounted? And are the proposed benefits dependent on a grid connection? This is in terms of the energy generation, carbon savings. Mr. Bell.
Yes, the benefits will be dependent on the grid connection being enabled and the project being energised and the export of electricity, as Mr. Kelly referenced earlier. The specific benefits of the grid connection itself will come forward with that application, probably by SSEN in due course. So they wouldn't be included as part of this application in terms of whether it's capex or construction employment.
Just on that, can I clarify something in chapter 13 of the EIR? It's 1.15, that's the document, electronic document, and it's paragraph 13.140. Yeah, 13.140, and this it's just so we're totally clear. It gives the estimated development and construction cost, and it's anticipated that this value we divide approximately as follows. It's got development planning costs, balance of plant, turbines, and grid connection costs. And it's anticipated up to 10% of the overall value contracts can be realised in the Highlands, up to 8.58 million. So I guess when we're looking at benefits, should that come down a bit to not include that 10% attributable to grid connection? Just make sure we're very clear as to what's attributable to this project. If you don't want to think about it and come back with an answer, I'm happy if that was just for our benefit to know what figure we should take.
I think we need to look into that and get back to you. We can't answer it fully now. So in the conditions session, I'll be asking for a week to come back on one or two points. Maybe I could include that as well.
It's paragraph 13.140 of chapter 13.
Grid connection costs.
It's just as a reference to grid connection costs. This has been raised in other cases, and it's just to be very clear what the benefits that are attributable to this project as opposed to other aspects.
Yeah.
We'll find out what that is.
Thank you, Mr. Whelan. Any comments on question 5D?
No, but someone's gone through that EIA in more detail than anyone could ever imagine to find that small print. It's really interesting, actually, to think about that in the concept of this, of a developer paying for their grid connection position, essentially, in the queue. They're paying something to the grid network. If that's then paying for part of the grid infrastructure
Well,
or not.
to be fair, it could be to the on-site substation, and that's what we'll clarify.
Yeah.
Just before today.
Yeah. It's really important, though, from an EIA perspective, to divide the two and to not ensure there is no double counting, because every time I get a grid application in front of me, it tells me exactly, you know, what their GVA is and how many jobs, etc. And they're all claiming that to be the benefit of that particular project. So you cannot have the generation station also claiming the same benefit. It's really, really critical. So, yeah, thanks.
Mr. Smart, have you any comments on this?
No, I have no comments on it.
Thank you. And Mr. Kelly?
No comments, ma'am.
Thank you. And Mr. Bell, have you any summing up comments, or we just wait?
Nothing further, thanks.
We're moving on to 5E, and this is a suggestion from Mr. Kelly that the proposed development, the question is, would it be likely to result in the displacement of existing benefits derived from existing renewable energy generation developments? And I think this is a question about whether the proposed development would have to compete with existing renewable energy generation developments for grid connections. Would this effectively just shift another energy generator off the grid? I think first of all to Mr. Bell, if you can.
We've discussed earlier the grid reform that's underway, and the whole approach of NESO is to allocate grid connections to projects that can deliver, those that are in planning or have consent. This project would form part of that, and there will be an offer made in March next year. So it wouldn't displace, because grid reform is reorganising the whole approach, and the benefits would be net additional benefits should they be realised. Thank you.
Is there a point here that if you get consent and you get your grid connection, but we don't have the infrastructure to transport any electricity, that you end up switching off someone else's wind farm to keep your wind farm going, because there's nowhere to put the electricity and we're not using it, there's no storage. So you're almost, in that sense, fighting against one another until we get the infrastructure in place to transport that electricity where it's needed, because we send it somewhere if we've got too much in Scotland.
But a lot of that storage is coming online now. If you go down the M74 down towards Hagshaw, on the right hand side you'll see, I think it's Scotland's biggest battery project is nearing completion. And in terms of grid works, it's not just the big overhead line projects that Peter mentioned earlier. There are other reinforcements going ahead now, and indeed a few were consented just a few weeks ago. So it's not a matter of this project being consented and then sitting there for a long time. There are other actions underway which are increasing that grid capacity every few months. And the government's approach is to get these consents in place, keep investor confidence high, and achieve the targets. It's not about pausing in any way until grid reform is underway or we see how that goes. Thank you.
I don't have much to add to what's been said, other than setting out that there's a major substation being planned, obviously just beyond this wind farm to the northeast. It's a substation, and you can draw a 2-kilometre band around that to then indicate where the commercial interest will be for batteries. So it's a fragmented system. It's not perfect. I think if this gets built, there's an expectation that more will follow. I don't know how you can put material planning weight on that, but essentially the grid needs to be improved. There'll be an impact associated with that. There'll be an impact associated with batteries. Each of those are standalone applications. They have to be assessed on their own merit. So some will be EIA, some will not be, and as a consequence of onshore wind, definitely. I'm not sure the battery sites, for example, are even in the carbon calculator, for example. You know, so it's difficult to assess that from the outset.
Thank you. Mr. Smart, have you anything to add?
You mentioned, Mr. Bell, sorry, you mentioned the battery storage that's coming online. What capacity is that, roughly?
I think it's around 800 megawatts.
800, yeah. So we've got a capacity at peak in Scotland of 5 gigawatts. We can produce 17 gigawatts. We need a lot more battery storage to cope with the 12 gigawatt excess. The thing is, even if it went into storage there, we've no way of putting it south of the border until the connections are in place on the grid. So I don't know how that affects the priority of schemes.
Just to add, there is a lot of electricity exported at the moment because it's part of the GB grid, and it's a key attribute of Scotland's economy is the export of electricity, and that's set out in the draft transition plan that we referred to earlier, which refers to the greater export potential. So the Scottish Government is not just looking at our own consumption requirements, it is very much export potential and the value of that to the economy. So that will continue, as will increasing the capacity of battery, plus the grid capacity, plus the generation capacity to reach that overall system which will deliver net zero. Putting it rather simply there, but you know, these are the key elements of it that will make it work.
But at present, actually, when we haven't got wind power, Scotland is a net importer of electricity as well. Would you agree with that?
Sorry, could you repeat the question, please?
That we may be an exporter of electricity when we have the wind power, but when we don't have wind power and there isn't storage, so I've added that to that, is the Scotland is a net importer of electricity because we have no wind power, so it comes from another source.
If there was a day where there was no wind blowing in Scotland, there was very low solar capacity and there was not much storage capacity, then there may be circumstances where there is import of electricity. I wouldn't dispute that.
I have no further comment.
Thank you. And Mr. Kelly, have you got any comments or anything that you would add to the statements that you had made?
No, your colleague summed it up perfectly well. I thought it's a grid capacity issue, and until that is resolved, then displacement is a likely outcome.
Mr Bell, have you any summary comments on that?
Nothing further, thank you.
Thank you. I'll take the next 2 points together. So moving on from the energy and electricity, it's I suppose the other socio-economic benefits that have been identified in the IER. So which of those proposed benefits are material considerations? And as suggested by Mr Kelly, could the benefits be delivered by any comparable wind farm anywhere else? Mr Bell.
In terms of the benefits, I've prepared a summary in my hearing statement of the renewable energy generation carbon savings, which would be material, security of supply, and then socio-economic. And within the socio-economic, there are a number of bullet points on page 22 which relate to payment that would be made on to various receptor groups, if you like. The direct financial payments stated there would not be material matters, including in particular the Community Benefit Fund. But the other socio-economic benefits, employment generation, creation, and training and so on, these would be material. And lastly, the biodiversity enhancement would be material.
Okay, and could they be delivered in by any other comparable wind farm elsewhere, or are these intrinsically linked to the Loch Liath proposal in site?
I think some are specific to this site. The biodiversity enhancement would be specific in terms of the megawatt capacity and the energy yield. This is a very windy part of Scotland, so you may have a similar megawatt capacity development, say in Comprising Galloway, but the actual energy yield would not be comparable in terms of the annual electricity production. That could vary substantially depending on the wind speed. So, trust that's helpful.
And there's no other parts that are specific to the site and location?
The only other element would be in the socio-economic benefits. There is the first bullet point there is looking at an aspect of training with the University of Highlands and Islands, and there is an element of the benefits relating to upgrading footpaths on Meal for Voney and a section of that, which would be specific here.
Do you think that first bullet point is a material consideration for us? Right, I was just asking that first one, your funding or joint working with the University of Highlands and Islands, whether that's a material consideration.
Possibly, if it was linked to training opportunities for construction. Possibly. Maybe.
I suppose, would you accept that the job creation would result from any wind farm? Numbers may differ, but any wind farm would generate and create jobs.
That is fair, but there would be jobs here in this area, which is affected to a large degree by seasonality. See that in the hotel here is closing down for a few months, so that may not apply in other parts of Scotland so much. But I take the point, yes, there would be that type of employment is probably typical for a wind farm, but the benefits it gives in a locality may differ.
Mr. Whelan?
Yeah, it's an interesting point. I think I've gone through the figures that are set in Chapter 13 of the EIA, and a few figures during construction, 13 full-time equivalent jobs in Highland. During operation, 17 full-time equivalent jobs in Highland. So they've stated that these jobs will materialise. If that's the case, then that's material, and it should be given weight, particularly in the Highland context. There's larger figures in there in terms of the Scotland context as well. That being the case, I'm unclear why the applicant would be resisting a local employment condition and then delivers on those jobs. And without that condition, I view that not to be material, if they're not willing to commit to that. In terms of training opportunities, and we touched upon, well, potentially material, but again, if it's not secured by condition, it's not. The community benefit figures, I agree, are not material. They're low, but I can't say that's a material consideration. That is what it is. That's what the applicant's willing to contribute. The footpath, Jamil furthering was derived through consultation with the applicant, and thankfully it was on the same estate. And actually, if you've walked up it in difficult conditions or when it's a bit soggy, there's clear opportunity to improve the provisions across the estate, and I'm glad that's been taken forward. But then it improves the walk to a summit where there's a significant impact as a result of this development. So take from that how much benefit that derives, and it's unclear. Keeps your feet dry. So the B&G, we've talked about biodiversity enhancement, but in terms of the peat impacts, they're still not quite meeting the guidance that's been set out by Nature Scott in terms of loss to compensation ratio. It's close, but it's not going strictly in line with what the guidance has set out, and it's not going beyond that. To me, if they're not willing to commit to the jobs, there's very limited benefit locally for this area. There's no evidence in the submission, I don't think, about any contractors that have been lined up to undertake the work, or option agreements in place for a local contractor to have first refusal, for example, that I've seen in other proposals. So it's just every developer does it differently, and I think if there's a true commitment to those jobs, they should be willing to enter into that condition to secure those jobs.
So if I can add to that, obviously we'll deal with the local employment conditions, submissions on that, and the conditions session. But in terms of the question you asked, ma'am, about the Highlands, the scholarships and the like, it does seem to me that that there is no connection to this particular wind farming. They're in the same category as community benefits, whereas employment jobs related to the particular wind farm are potentially relevant if secured, but from a legal perspective, they begin to clearly fall foul of the tests for legality set out in LSIC. So I noticed the caution expressed by Mr. Trinick on the other side, and I would suggest that was caution is well expressed.
I said what Mr. Finney says. I see why he says it. My point is that if an element of that training or scholarships for training relates to construction, that may bring benefits and materiality, but probably not to this project. I agree. For the future, maybe.
Thank you. Mr. Smart, have you comments from the Community Council?
No, we've no comments.
Thank you. Mr. Kelly?
Nothing really further to add. Mr. Bell has confirmed that a significant number of the benefits would arise from any wind farm anywhere, but he's also pointed to specific benefits in relation to the habitat and biodiversity enhancement and footpath enhancements. So really nothing more to add.
And Mr Bell, have you any final comments on this point?
The only point I would make is a planning one that I know perhaps more for the condition session, that you're being asked to disregard employment benefits if they're not secured. I would just say that Scottish ministers have never taken that approach in any of the 39 section 36 consents or decisions issued since NPF4 came in, to disregard employment benefits if they're not secured by condition. But as I say, that's maybe to be debated just shortly. Thanks.
Thank you. Just looking at the time, I would suggest that we take a 10-minute break, and or just over 10 minutes, and come back at 3 o'clock. Okay, thank you. Incompatibility between NPF4 and the Highland Wide Local Development Plan and its supplementary guidance. Mr Bell.
Thank you. In my hearing statement, I drew attention to an appeal decision notice called Meal Buoy, which had examined the matter of compatibility between the LDP and NPF4. I would say there are some incompatibilities. Now, the Chief Planner letter tells us that that's where there's a conflict or something is contradictory. I think one of your colleagues put it quite well in another case, namely the proposition that if you were to apply an NPF4 policy and an LDP policy and you get a different answer with that, that would be a good test of whether there's an incompatibility. I think policy 67 in Meal Buoy, the reporter said there was some inconsistencies overall with the development plan, and I think it was a matter about weight to be given to benefits, and the fact that policy didn't deal with the localised topic that we've been discussing today. I wouldn't perhaps go too far to say it's an incompatibility, because I think the Highland Policy 67 has been a very good one over the years, and it's not problematic really to deal with. However, Policy 57, where it deals with wildland, I would say is an incompatibility, because that's very different to the NPF4 policy position, but that's not a matter we're engaging in today. NPF4 Policy 4 has got a slightly different test in NPF4 in relation to acceptability of impact on local landscape areas. That could potentially give rise to a different outcome if you were to apply the different policies. And you ask about the onshore wind supplementary guidance. And again, I think Meal Buoy was informative about that, saying that it focused on the spatial framework approach. It expanded on Policy 67, and the reporter placed more weight on the framework. And I think that would be the right approach. There may still be some elements of the supplementary guidance that are informative, though, so I wouldn't totally discount it. And I wouldn't say it is. There are incompatibilities, but not fully incompatible, if that makes sense. Thank you.
Thank you, Mr. Whelan.
I'll deal with that. In essence, I more or less agree with what Mr. Bull has said. There are elements of the Highland Wide Local Development Plan dealing with wildland and of the supplementary guidance dealing with spatial framework which have clearly been overtaken by NPF4. But neither of them, those elements have not featured in either party's case. So those matters are not relevant in terms of particular decision making in this case. Dealing with the supplementary guidance, the parts which have been referred to, the criteria and are not policy tests, they're just factors to aid the decision making process, and both parties have given evidence on those with no suggestion they're incompatible. and the assessment of Loch Ness and its surroundings has been relied upon by both parties to a greater or lesser extent. So there's nothing incompatible there. In terms of the overall approach, no doubt MPF4 is a step forward from the HWLDP, but I commend Mr Bell's approach to looking at the outcome, and in our submission, whilst MPF4 says more about weight, there's nothing incompatible with it as to what the LDP says, and applying both should lead to the same outcome, and that's the approach. There have been many other decisions on the Highland Wild Local Development Plan since MPF4 came out, and that seems to be the invariable approach that reporters have taken and supported by Scottish ministers. And I think the finding of incompatibility in Milbury, or the suggestion of incompatibility, is perhaps a bit of an outlier, but I can understand why Mr Burrell refers to it. But I think overall incompatibility is not a live issue in this inquiry.
Thank you. Community Council, Mr Smart.
No, no comments.
Thank you. And Mr Kelly.
No comments. There was one thing I was wanting to raise right at the start, ma'am, but I didn't get a chance to jump in. One consequence from my blackout and car accident is I'm suffering from bouts of severe fatigue. I have one coming on just now. I'm not going to leave the inquiry. I'll stay in listening, but I don't actually want to say anything beyond my written evidence on the next set of topics. I'm just too tired. I apologise for that, ma'am.
And that's the thing, I appreciate you taking the time to take part, and we have your information, we've got your written submissions, and we'll take those as read. So thank you very much.
Thank you.
Mr Bell, any final comments?
No, not on the development plan. Thanks.
Okay, with Policy 11 on energy, there's been a lot of evidence provided so far in terms of localised and design mitigation. I suppose my question is there anything to add to that and above to what was discussed at the inquiry sessions? And really, if people have any comments about how the proposal would maximise net economic impact.
Let me start off. Yeah. In terms of maximisation of net economic impact, we've been over just earlier the benefits. Although there's been quite a debate at inquiries or in appeals about what maximisation actually means, because there's been no guidance on it, the approach of the ministers has been informative to look at what they've done, and in all cases they have made reference to what might be termed the conventional reporting of gross value added, direct and indirect job creation, capital expenditure that would be involved, and they've taken the view that that would deliver net economic impact for Scotland. They haven't probed further than that or raised questions on whether such benefits would be maximisation. You will have seen from the list of benefits that the applicant has sought to maximise by going further, perhaps into some non-material aspect of benefits, but that still delivers, we would say, a maximisation. And just giving you an example of the approach of ministers in the Bunloyne decision, which is before the inquiry, which is document 11.050, paragraph 108, the ministers say, whilst the overall net economic benefits are estimations of the effect of the proposed development, the Scottish ministers are satisfied but the development has the potential for positive net economic benefits for the Highlands and for Scotland. So that would also be the case here. So the applicant's position is short that the benefits have been maximised and would be in accordance with Policy 11C. Thank you.
Did you want to add anything in relation to Parts E on localised or appropriate design mitigation, or is the evidence we've already heard on landscape and visual kind of covered that?
If I come in first, then Mr. Trinick will add. Thank you. My position is that in dealing with localised, there are two aspects. One is the spatial extent, and that was covered in the landscape evidence yesterday. There seems to be agreement on that, apart from the distance of significant visual effects. So I think there's a strong geographical aspect to understanding spatially where are those effects and where are the significant effects for landscape and visual. But the second step in that would be looking at the sensitivity of receptors that are affected. And I think Mr. Daly was touching on that in his landscape evidence. So I think from a planning perspective, it's understanding the geography and the extent, and then what is affected, and is the harm of those effects such that the development is acceptable or not in the balance. And we've got the broad spatial planning approach in Policy 11, which is if you're not affecting a national park or a national scenic area, then you're in an area where in principle you have a good starting point. And then it's a matter of looking at, are there receptors that are so sensitive that the development is unacceptable? And that's a planning judgment based on sensitivity of receptor, the degree to which it's affected. But bearing in mind that tail end of Policy 11 that talks about contribution when weighing up those impacts, we've been over the targets this morning, so we don't need to go over that, and you will have now the landscape evidence of where these effects are. And in terms of a sort of calibration of what is localised, I've drawn out two decisions, Cleansade, which is 1311, and Bunloin 1310, two schemes, turbines at 200 metres to tip in Highland, where you will see comparable distances there. So that gives me confidence as planning witness that the landscape and visual effects based on Mr. Walker's evidence would be localised. So that general acceptability position is engaged. But then you need to go that step further about look at the specifics of the scheme, as I've just talked about, in terms of the receptors and how they are affected. The applicant's position is that the effects that would arise would be acceptable, as we've set out in our evidence. Yes, so they're overall largely localised. That's the position. I think the other factors I would just draw into that position are the wider policy context. So in the onshore wind policy statement, where it deals with NPF4, in section 3.6, it has underlined that the need for taller, more efficient turbines will change the landscape. And it talks also about the assessment criteria in NPF4 has been updated, including stronger weight being afforded to the contribution of the development to the climate emergency. So the position, if you like, of the bar of acceptability, I would say, has shifted with NPF4. It has to have done if you're giving more weight to something. And I think the onshore wind policy statement being published at the same time as NPF4 is a powerful tool for the decision maker. It's clearly not carte blanche to grant consents, but there's a clear steer for planning judgment having been changed.
Do you want to add anything, Mr. Trick?
No, thank you.
I'll maybe just pick up the points about is it localised, is it not, and how we consider that. And I appreciate you've heard the evidence already from Mr. Daly in terms of the geographical extent, but there's a few things to consider. What's in that geographical extent? Is it a world-renowned tourist attraction? Is it the best known landscape in terms of a glen, if it's Glen Affric? Is it localised if it spills across one glen and then spills across another glen? In my mind, as reported in the report of handling I put to committee, the significant impacts that are occurring out to 20 kilometres in this proposal. 20 kilometres seems a long way, and it's not just distance, it is the sensitivity of the receptors that are captured. And a lot has been said about the geographical extent of Loch Liath, and it's a narrow cone of visibility that's spreading across the loch. But for every proposal I've seen in Highlands in terms of our approach, is to remove, or as much as possible eliminate, loch level visibility. We've been really successful through the design and reiterations made to other proposals to achieve that. It's set out really well in the onshore wind SG. It's set out in every pre-application pack that we give applicants for proposals across the Loch Liath. You can see the number of consented schemes that we've achieved around this area whilst upholding the key principles set out in the onshore wind SG. In my mind, this proposal goes beyond what's set out in our development plan in terms of acceptability, and for that reason I was pretty clear to the applicant all the way through the process that what they had designed was an inappropriate scale and not well designed. It's not localised and therefore should not be supported. James, do you want to come in on the social aspect?
I'll come back to the maximising net economic impact. The actual terms of obviously 11C go on, including local and community social economic benefits such as employment, associated business and supply chain opportunities. With respect to Mr. Bell, there is no evidence that they have been maximised, or that, and we'll come on to this, that the local, and particularly in a local sense, and certainly not secured. The one, and this position the Highland Council has taken at successive inquiries, this is a new requirement that has come in since the proposal was brought in force, so you wouldn't expect to see that in the EIAR. There's no guidance as to how to approach it yet. The fact that they may not demonstrate compliance with this doesn't mean that they don't comply with Policy 11 overall, but it's a factor to take into account. It is very unlikely to be decisive. As to the discussion on localised, just to add to what Mr. Whelan has said, the discussion by the reporter in Foresight report, which is our CD 1211, makes it clear, and I don't think there's a dispute with Mr. Bell on this, that geographical extent is not the sole factor, and you need to look at other factors as well. I don't need to add to what Mr. Bell has said on that. Sorry, Mr. Whelan has said on that. Thank you.
Just one question on the socio-economic benefits that Council considers have not maximised, in particular in a local sense. Could I just ask Mr. Finlay a question through you as to what does the Council consider the applicant should have done in order to satisfy that concern that they have? Thank you.
I'm more than happy to be cross-examined. Yeah, it's difficult to see how one maximises that, but the Council, well, the short answer is agreed to our local employment condition, because that is the only, not necessarily that condition, but something which secures or seeks to secure employment, local associated business, and local supply chain opportunities. And that would at least contribute to maximising net economic impact in the sense that it's set out in Policy 11C.
Just come back on that. There are two separate issues here. One is the condition securing it, and the other is, has the applicant done enough? We'll talk about the condition later. I'm not sure what maximised looks like. What I am sure of in this case, on the evidence, is that the applicant has done all it reasonably can to advance and bring forward benefits from the development, material benefits, as discussed by Mr. Bell. Whether or not those can be secured, we'll discuss in the next session. But there is no definition of maximise, as repeated reporters and the ministers have recognised. We've done what we reasonably can.
So I can respond to Mr. Tringham. I've noted in various, and will note in due course, various commitments to local employment matters that the applicant has made. And to some extent that, I was perhaps too hasty in my criticism, those commitments have been made, and that is a step towards maximising supply chain opportunities. So I can detail those commitments in due course.
Thank you. Mr. Smart?
Yes, just one or two comments, if I may. The payments per megawatt that are suggested, the 5k, has been in place since 2014 and is discretionary. And it won't be implemented until the project's energised, and then it's protected against inflation. But that's been eroded, that amount of money, over the years. People are now 11 years on. There'll be no jobs locally after construction. And on the UHI, there's one apprenticeship offered, and I don't know if there has been, and you can correct me on this, if there's been any liaison between UHI or the schools, and any reference to supporting surgeries and social care. And I know that's in the manifesto of one of our local MPs about contributions to communities from energy projects. That's just one comment. And then looking at localised, it was interesting from Mr. Day's evidence this morning. When you look at the visual impact from the Loch for visitors, overseas visitors. And it is important people come to see Scotland, they come to see Loch Ness and the Great Glen. And that's important to the whole area and the economics of that. And any detriment to that by the visual impact that we can see from the wire diagrams that were shown, we've got lots of visitors coming to Loch Ness. And I can tell you, I live in Drumnadrochit. The boats that go up and down there from the Clansman and Dockford are taking hundreds of visitors who've come in boats to Invergordon as well, the port there. So it's the impact of the view there now is really important. And if we're to have taller turbines, by way of efficiency and the energy produced by the project, then they're highly visual from the Loch and probably in an inappropriate place. They are tall, so if you see them, well, can you say, well, they shouldn't be there? Find another site where they're not seen. That was my two comments. Thank you.
just a couple of points in response. Just say the University of Highlands and Islands, the applicant has a long-standing relationship, so there has been engagement there. I think you were just maybe questioning whether they had been contacted, but
my apologies if that's
no,
the case.
that's okay. There's certainly that is the case, that they have been. The Community Benefit Fund is £15 million over the lifetime of the project, but notwithstanding that is a commitment, there are these other financial commitments. So the overall cost for the applicant goes beyond the £5,000 per megawatt there. But just to make that clear, thank you.
Thank you. Moving on now to policy 4, natural places, and it is a question about understanding the intention of the policy, or what we need to consider. If the proposal would be supported by policy 4C1, do the reporters need to consider 4C2? And Mr. Belfer.
I think Mr. Trilling is going to deal with this. Well,
4C you'll do.
sorry, we're the other way around, 4C. So, yes, the position of that is that if the proposal does not conflict with 4C1 as the objectives of the, in this case, the Glen Affric NSA and its overall integrity would not be compromised, or in relation to the special qualities, then there would not be a need to go on to address the balancing test in 4C2.
James will keep me right, but that doesn't reflect my understanding of the policy or its application. But my notes, and I'll go from them, and James, feel free to intervene. But essentially, I think the policy should be applied in 2 stages. So the first test, being part 1, is for the decision maker to be satisfied that the proposal does not affect overall integrity. And then the second part 2 of the condition is that engaged, and the decision maker must be satisfied that the proposal's significant adverse effects on the special qualities of the designation are outweighed by the social, environmental or economic benefits of national importance. If both tests are cleared, then the development can be supported under that policy.
I think it is both tests because it's got an or. It's
poorly drafted.
There's C1 and then there's an or in the C2. And I accept the fact that they two appear to deal with different things, but it's the use of the word or, which is why we raised the question to get parties using it. That's the thing that I wondered about, because they are slightly different, but it's the or, it's not an and.
I mean, this is not a new policy. This was in SPP, and I remember dealing with this way back at the Beale Denny inquiry 20 years ago. And there was a question put. You know, their proposition was there are 2 ways to satisfy this policy. It's one the first limb or the second limb. It's not having to apply both limbs.
I would accept that. But the first limb is objectives of designation and overall integrity. It's not just integrity. So you would need to satisfy both of those aspects in order to satisfy limb 1. And that's broadly comparable with D1, actually, which refers to integrity and qualities, but they're obviously different aspects. You would only get on to C2 if you fail C1.
Yes, but asking through the reporter, is it the Council's case that we breach 4C1 in this case?
Don't think there's any integrity argument being put forward for this or not.
That was my understanding. It was agreed that the overall integrity would not be compromised. That's my understanding.
Yeah.
So the question was really, with that understanding, did we have to look at C2? That was the question, which is why it was. So I just wanted to clarify that. Okay. Mr. Smart, do you want to comment at all on this? I know it's quite a technical point of policy?
No, I've no comments on that. Thank you.
And again, looking at how should Part D of Policy 4 be applied. I'm really asking, would any significant adverse effects on the integrity of Loch Ness and Dudley Hague SLA be clearly outweighed by social, environmental, economic benefits of at least local importance?
Do you mind if I start? I mean, firstly, the parties are agreed that there's no, the integrity is not in play in terms of the SLA, or indeed the NSA. So the only part of D1 that's in play is the qualities for which those areas have been identified.
I'm grateful, and that's helpful. I think 4D is an unfortunate policy in the sense that under 7D1, if you breach, if you have significant adverse effect on the integrity of the area, that takes you into D2, the balancing tests. However, if you have no adverse effect on integrity and yet you have a significant adverse effect on qualities falling short of integrity, you breach the policy without the chance to bring in the balancing exercise under D2. So it's a rather unfortunate policy. It has been, thankfully, recently addressed by your colleague Christopher Warren in the Craighead decision, which is before the inquiry, as document 1173. And you might want to go to that at paragraph 21, where, I'll wait till you get there. Where Mr. Warren wrestled with the same thing that we're wrestling with and said what I've just said. However, that would mean significant effects on some special qualities but not the overall integrity would remain contrary to policy D1, with no means by which this could be reconciled under D2, despite it being a lesser effect. It seems to me logically necessary to consider whether the effects on special qualities will be outweighed by the benefits, i.e. engaging in Limb 2, and pragmatically, if not legally, I agree with his approach. It's the only sensible approach to the policy. Yeah, well, that's not site specific.
I'm almost with Mr. Trinick on that. It seems it is unfortunately worded. There's no doubt about it. That's the position Highland Council's made clear at many previous inquiries. I reiterate that simply because you fail to comply with an aspect of policy 4D, you're not necessarily contrary to policy 4 as a whole. And even if you were contrary to policy 4, you're not necessarily contrary to the development plan as a whole. And that I agree with Mr. Warren's suggestion that it's logically necessary to consider whether those effects would be outweighed by the benefits. I don't understand him to be saying that's done by applying D2, but it's done as part of his overall balancing exercise, with which I respectfully agree. It is a factor as to be put in the overall balancing exercise as to acceptability. There will be disbenefits as a result of impact on those qualities, if you find there to be such. And the question is, are they outweighed by the benefits along with all other matters? So with respect, although I think Mr. Trinick and I interpret it slightly differently, the approach of Mr. Warren to put those into the balance subsequently seems to be the appropriate way of doing it, and he doesn't appear to have taken a conflict with policy 4 or given that any specific weight.
I agree, and Mr. Finley's right. At paragraph 89 of the decision, that's where the balance is struck, but it's not struck with specific reference to D2, just an overall balance which is struck.
Yeah, I was going to say that. I think it's part of the overall balance as opposed to engaging D2. Yeah.
Okay, Mr. Smart, have you any comments on this discussion?
No, I don't have any comments. Thank you.
Thank you. If we move on to policy 3 and biodiversity, this is really just, with respect to that policy, just looking for clarification somewhere within the documentation of what forms mitigation and what forms enhancement. There's a few things I was a little bit confused about, but if you can point me to a document or a paragraph number, it would be appreciated.
Yeah, certainly. I think in the EIA report, Chapter 8, Paragraph 8.42 sets out the approach taken in the EIA to the mitigation hierarchy, and it explains the stages sequentially, namely avoidance, mitigation, followed by compensation, and it describes each of these stages and how it's been applied within the EIA process and in the chapters. So that would be, I would say, the key reference for you. And then on your point about, if it's still about biodiversity enhancement, there is within the supplementary environmental information, outline restoration and enhancement plan, which is 2.056, which contains the specific enhancement measures.
Thank you. Mr. Whelan, have you any comments?
No, I think our original report on handling, it might be worthwhile just to read it in context of paragraph 7.168 and 69. It explains that 11.1 hectares of prior to peatland will be impacted by the development, 6.4 hectares will be directly lost, and then 4.8 hectares will be indirectly impacted. And then the updated outline restoration and enhancement plan, which is the SEI Appendix 8.5, it now includes a new area totalling 104.8 hectares of peatland restoration. So that represents a ratio of 1 hectare of peatland lost to 9.4 restored.
Thank you. Mr. Smart?
Yes, just on the point of peatland restoration, how is this checked? I haven't seen any plans on the areas that will be looked at for this in the development area. And has that been looked at as to what was supposed to be done by the Glairy Wind Farm and in the Glairy extension as well? That's one question. I'll come back to the second one in a minute.
I think if we can maybe take that with the question on policy 5, soils, which you had raised concerns regarding peat, and there's the question there about how the proposal being designed in accordance with mitigation hierarchy and in a manner that protects soil from damage. If you think that question might cover Mr. Smart's question there.
I think so. Deal with it there. I suggest we could cover
yes, that's fine on that one. Yes.
There's just one further point raised about the ratio of mitigation or peatland restoration. I think Mr. Whelan used the word strictly in accordance with the Nature's Got guidance. There was a matter that's been recently aired in an inquiry report for the Garvery project, which is an inquiry report that's before the inquiry, and it's paragraph 166, 167, and also paragraph 250 of that inquiry report, where the reporter deals with the specific Nature's Got ratio. And in that case, the applicant had come in less than the 1 to 10 ratio, but the reporter's position was that that did not represent a mitigation deficiency. It was not mitigation deficient was the conclusion at paragraph 250. So the approach is certainly to deal with it seriously, to apply it, but it's not a strict accordance with has to be 1 to 10. There's clearly a view taken on the circumstances of each case, depending on what is proposed.
I agree. There's room for interpretation as guidance, so it's not a strict requirement. However, we are pushing every developer as hard as we can to make sure that they can offset their impacts as much as they possibly can across the estate. Some can because the estate requires areas to be restored. Some are really struggling for areas to find for restoration. So I accept the position that there's not an objection here from Nature Scott or indeed SEPA who look after the peat interests. So.
Sorry, can I just add one point that I didn't get to on biodiversity? We've had some correspondence between the applicant and our community council on ecology, and we haven't replied to that. I don't know when it's appropriate, if we can, or would be allowed to put forward some of our comments on that. Would that be acceptable?
Well, we haven't seen the letter from the applicant to you, so it's not before the inquiry. I would encourage you to enter the dialogue with the applicant and respond to that as in parallel to this process, and definitely speak to them if you get a chance to at some point after this or in the next few days. But it's not before us as an inquiry, and it's maybe quite specific to how they can deal with your concerns. I don't know. We haven't seen that letter. So it's, unless you've got something general you want to say, I don't think it's appropriate to go through a response to that letter just because we haven't seen it. But if there's any general comments you want to make about the biodiversity, then feel free to do that.
That would be fine. I was just wondering when we could do that. I thought the matter was maybe, it's all going to be written correspondence between us. If that's acceptable to the applicant, we're fine with that.
And we definitely encourage that. Just because this process is an inquiry, we'd encourage parties to still have a dialogue and work together, regardless of what the outcome might be as part of this process.
Exactly, that's fine. Okay, thank you.
Are you happy to move on to soils, Mr. Smart?
Yes, I am. Thank you.
You want to discuss, I suppose, your concerns on the peat aspect. I think you started on that anyway.
Yes, I did. Just on policy 5. I mean, policy 5 provides significant protection for peatland and carbon-rich soils, and maybe we could have some advice on this as a community council. But these areas our interpretation is that the area should have been avoided. And as I said before, there can be extensive damage to peat either side of the roads, turbine foundations, and also the floating road as well. And that floating roads do have a big effect on the hydrology of peatland. This particular area has a lot of lochans. The foundations of the turbines are dispersed among the lochans. And in that respect, I think the effects on the hydrology of that will be profound, and that this is not an appropriate area to be building a wind farm in.
Thank you. Mr. Bell?
Thank you. Just starting with policy. This policy 5 is one of the material changes from the previous policy position in SPP, where policy 5, item C, Roman 2, now has a specific carve-out for renewable energy development within peatland subject to assessment. I think the government has recognised that there will be a need to have some development that does impact on peatland, but appropriately. And as Mr Whelan said, the Council was very aware of that and scrutinises developments that have impacts on peatland, as does Nature Scotland, SEPA. The mitigation hierarchy has been followed based on a peat survey that was undertaken for the site with specific probing, physical probing, to avoid areas of deepest peat, and then apply appropriate mitigation. You mentioned one of the specifications of that, the floating road techniques. There can be issues, of course. I'm not saying there could not be issues with construction, but there is a planning condition we'll come on to later with an environmental clerk of works to be overseeing works as well, and to ensure that conditions are applied fully. So there is detailed information in the EI report. Consultees have been engaged on it. The matter has been deemed satisfactory, but that's not the end of the matter. As I say, there is a role for conditions and further controls to be applied during the construction phase.
Yes, thank you. It's just the way we seem to be at a bit of a loss here, though, in that maybe SEPA and Nature Scotland have accepted this. But given this policy in NPF4, and it's nationally important, this area, is its classification 5 peatland, so it's deep. And it comes back to this carbon balance and the carbon calculator as well. I mean, a floating road will be 2 kilometres, and it may be more, it might be slightly less when you come down to plan it. But that's a mile and a bit of floating road, and effectively it will have a big effect on the hydrology. So, which will mean that it'll squeeze the soil. It will let off CO2 in its lifetime, and continue to. So that's why I'm looking at the carbon calculator being not fit for purpose, and you cannot quantify the amount of greenhouse gas that will come off that.
I think just to finish on the calculator, we had quite a lengthy discussion earlier, but there are assumptions made in the calculator on impact on peatland, so that has been taken into account. But insofar as the parameters of that model do work, I don't think there's much more I can add in terms of the mitigation approach, and there is a net carbon saving benefit overall with the project.
Thank you for that. I suppose it'll come down to, if it does go into more of a debate as to reasonable mitigation, what that implies from. I mean, we could say, should there be a hold on this until this carbon calculator is available, so as we can then quantify it and look at it, what would be reasonable mitigation.
And that's possibly something you might want to pick up on in the condition session, about some of the conditions there that might provide some mitigation.
Okay, thank you. Did you have any comments, Mr. Whelan?
Just in terms of the conditions, we'll maybe touch upon it, but in terms of reverting to the standard condition for the ECU conditions, I think in this instance, given the slight circumstances, there's justifiable reason to align any condition wording along with SEPA's request. There's lots of lock-ins here. It's a difficult site to
develop. Can we leave this to the condition session?
Yeah, it's relevant, that's all. In terms of mitigating the impact on soils.
That was linked to the actual application. I think if we're going to look at the actual wording of the condition in the condition session, that would be a better time to take it.
Okay, thank you. We'll move on to point F. And it was just asking, first of all, Mr. Bell, any comments on the relevance of policies 14, 18, 25 and 29 of NPF4?
Just briefly, I don't think they are particularly relevant to this land use type. I've not seen the ministers engage with those policies at all in any decision letter, and I didn't deal with them in the hearing statement for that reason. Thank you.
Mr. Whelan?
I think if you read the detail of the policies, there's some interesting content. I've not seen, like Mr. Bell says, being applied to wind farm development, but that's not to say they cannot be applied per se. It is open, and NPF4 should be read as a whole. There's no reason why the policy should be excluded. When it talks about policy 14, the content is interesting in terms of its general sense of, irrespective of how well buildings or structures are designed, there's a mixed opinion if a wind farm development can be considered healthy in the terms of that context and mental health. They remove areas of tranquility, but some people will see them as a positive step towards addressing climate emergency, which might be better for their health and their well-being. So it depends on your interpretation of application of these type of policies. In terms of renewable energy, I would read them, have a consideration of them, yes. How much weight to be attributed to them, I suggest limited.
Just to confirm, they form no part of our reason for refusal.
Thank you. Mr. Smart?
The only comments we have as community councils, and regularly comes up at meetings, is looking at the road safety upgrades that we're looking for and discussing all the time. Footbridges, speed restrictions, footpaths, and looking at national walking and cycle routes, quiet roads, repairs. Some of the policies there, 14, 18, 25, we could say they are relevant.
Thank you. Mr. Bell, any final comments?
Nothing further, thanks.
Okay. Thank you. Moving on to G, and understanding that there is the nationally expressed need for renewable electricity generation. Is this the right development in the right place, as referred to in NPF4 National Spatial Strategy?
The applicant's position is yes. The approach to right development in the right place, I would say, is to apply the policies in NPF4. It's not, there isn't a specific policy on right development in the right place. So it's about looking at what the relevant policies are, applying those, and then NPF as a whole, as we've talked about. And I think, as I said earlier, where you've got largely localised impacts, and just to reiterate, all the effects don't need to be localised to be acceptable. It is, we shouldn't be totally hidebound by having to be localised, but in this case they are largely localised, and where you're not impacting on national designations unacceptably, and we've got a position of no objection from consultees by the statutory consultees by the council, so Historic Environment Scotland, SEPA, Nature Scot, all satisfied, then we would say, given the need case, which we talked about earlier, for the right development, nationally important, at this location that satisfies those spatial matters, then that is a position of support, I would say, in applying NPF4 and then NPF4 as a whole. Thank you.
No, I don't agree. It's not appropriately scaled development for the location.
Thank you. Mr. Smart?
No, we have the same opinion as the council.
Okay, thank you. I think we'll move on and not discuss question 8, but if parties are agreeable, we'll just continue straight on to the conditions session. Okay.
Should we have 2 or 3 minutes just to swap positions?
Oh, of course.
Okay.
It's probably worth just ever having open the latest draft of the conditions and the paper you circulated yesterday.
Just have a question to IT man. Rebecca's going to want to talk. Which microphone should she use?
Was there one?
Yes, but I moved it and I can't remember which one it is. So I messed it up.
Let's have a look. Is
It's a spare one.
are either of those ones next to you spare?
That, yeah.
Well, you can have this one. Yeah.
If we,
It says seat 2 on it.
we'll need just 30 seconds and
Okay.
I'll... And off again.
Hello?
Okay, thank you.
Okay, thank you. So we are working from, as Ms Cragg said, the latest draft of conditions from the 4th of November, but also the document circulated yesterday. So there's been a number of suggested changes to conditions. and we'll go through them in the list that was on the agenda and as they're listed in that table. So first of all, the applicant is proposing amended wording of Part 1 of Condition 6, Design of Wind Turbines. Do the Council accept these new proposed conditions?
Sorry, I'm just finding the right document. So I can see from the amendment, from the discussion that took place in the first day, I think which is yesterday, that they are introducing a specified blade length, which is a maximum length of 86.2 metres. There was discussion yesterday over the variation between what was set in the LVIA and what is now proposed, and that being representing a 5 to 10% increase. Is that correct? That the hub heights essentially will come down as a result?
That's right.
And on the basis that that degree of variation I don't have a particular issue with. I think leaving it unspecified I would have an issue with, so I can take the wording that they proposed as agreed.
Grateful. Just there's a bit of poor wording there. It should be unless otherwise approved, obviously by the planning authority, not agreed with. And I should say that we have consulted with two relevant disciplines, or perhaps the relevant disciplines, birds and transport, and have emails confirming that a maximum blade length of 86.2 metres would be okay from both the point of view of both disciplines. So we have landscape and visual, birds and transport covered. Sorry, my voice is going.
Thank you. And then moving on to Condition 9, micro-siting. Again, the applicant has proposed changes. And do the Council accept the new proposed changes?
Actually, ma'am, I think it's unfair to go to the Council first, perhaps, because subsequent to drafting this, we have heard from SEPA, who have said they're happy with the wording in, where is it? Which one is it? Which subparagraph? Part C. Has a greater overall impact on peat than the original location. They are content with that wording, but they do not want hard standings excluded from the condition. We only received that email today. I said earlier on I would ask for a week after today to come back to you on one or two conditions. We would like to go back to SEPA and try and resolve that, and then bring to you a final response within 1 week.
Can I just understand the issue, why you're resisting this?
Sorry?
Can I just understand the issue and why you're resisting the standard wording on this condition?
Yes, certainly, because simply micrositing onto deeper peat may actually mean lesser effect. If you're, say, it's a small pocket of deep peat, it's going to be less of an impact than cutting into the edge of a wider area of shallow peat.
That's I can kind of get that bit.
Yeah.
It's the exclusion of floating tracks or hard standing. That's the bit that you're not happy with. I understand. I can see the rationale between the deep peat and the wider, shallower peat. It's a bit about the excluding floating tracks or hard standing.
I'm not saying we're not happy. I'm saying we want to go away and think about what SEPA have said to us, and then come back to you within a week.
Thank you. So, Mr. Beelan, are you happy with that approach?
I'm comfortable with that approach. Thanks.
Obviously, the Council would be given a chance to comment as part of that process.
Absolutely, yeah. And indeed, Mr. Smart, if you'd like to hear from us on that.
Yes, I would. Thank you.
Okay, condition 11, site investigations. This is a question, it was for the council, as to whether if the site investigation works required benefited from permitted development rights, and if there are no permitted development rights, then the condition, my understanding is the condition would be required. Let's just take your views on that and what the applicant has suggested.
Our view is that permitted development rights would apply, providing the ground works and the disturbance cause would be restored within a 6-month period. So that's the approach taken. On any
Can I
development
ask you why you think they apply?
because essentially, because you have a consent, doesn't necessarily seem...
Is it not they flow from the consent as opposed to having PD rights?
It's Article 3.8 of the General Permitted Development Order that in EIA cases the PD rights are removed.
Okay, it's good to know. It's good to know. So,
But on that basis, if there's no permitted development rights, you are doing these works through the deemed plan permission that you get if this appeal is granted and the minister made that decision. Therefore, why is the condition being deleted? That's the bit I can't follow through on.
Haven't quite done that. We've added to the next condition, no developments save for site investigation shall commence.
But does that mean you can go ahead and do site investigation without doing anything in condition 12?
That is the intention.
So that seems to me to be a worse position than that condition is from a point of controlling the development.
Well, first of all, site investigations have been defined. Are they at the end of this document? Yeah, okay. Try and find it. Site investigations means ground or geotechnical investigations. So it's simply taking samples to investigate ground conditions. That is all we will be doing. Secondly, the condition, if it stands as it is, would still require the Environmental Clerk of Works being appointed to monitor compliance with ecological and hydrological commitments required by conditions and the submission of the bird protection plan under condition 23.
Are you not deleting that condition?
Well, that was a proposal, but I was answering your point. Our proposal is as in now condition 12, save for site investigation works.
And you're taking that approach because it's GIS and just groundworks, but if you're doing groundworks, would you not potentially need an Environmental Clerk of Works to make sure you comply with ecological and hydrological commitments?
We've changed our mind, we'll retain condition 11, that's fine. I'm not going to fight.
That's short circuit, so thank you. Are you going back
Easy.
to the original wording and
That's fine.
condition 12?
10, number 11. Yeah.
That was my fault, not theirs.
sorry to interject. I had one question then. If the PD rights don't apply to EIA development, it's providing that the EIA development is enacted, that permissions then locks on. What if the permission's not locked on? So essentially, if you can have a consent on a piece of ground, be it EIA development, that permission is not started, the PD rights would still apply to the ground for any SI.
One for outside the inquiry perhaps, but I'm not sure if there's a relevance now.
I suppose it depends if you did the GI and saying that's commencement of development or it's not.
We're specifically providing that it's not. I mean, we have to make site investigations to determine ground conditions to enable us to finally place the turbines and other infrastructure so that we can start the development.
I don't want to labour the point, but
Yeah.
essentially if you wanted to go on site to do GI, you'd have to satisfy all your pre-development commencement conditions. And I want to avoid that as much as possible.
I think maybe that comes down. That maybe comes down to the definition of site investigations. So you may want to look at the definition of site investigations when you come back. And if I get what you're saying, because I don't think that's the intention that all of the pre-commencement conditions have to be satisfied. But if your definition of site investigation is sufficiently clear that it doesn't commence development, my concern is this: if taking this condition out would mean there's no controls over complying with the EIA. But I think now we're happy that the condition's going back in, and if you can be happy that it doesn't trigger the commencement of development, but there's sufficient control, that might come down to the definition of site investigations.
Totally understand that. As long as it's defined what the scope of works are in the consent, that's fine.
Very fair point, and they are defined. If you're happy with the definition, then I think we're there.
And Mr. Smart, from your perspective, putting this condition back in means that there is some oversight from the environmental clerk of works. Whereas taking it out was taking away that supervision element.
But yeah, there's an advantage in having the clerk of works involved. Yes.
Yes, so the applicants are now saying they're happy to keep that condition in for that kind of level of oversight.
Okay, thank you. Condition 12, site enabling works. And this is where we'd ask, should there be reference be to the environmental clerk of works, which the applicant has proposed, and again, at the council, you can content with that, you are. Thank you.
And the other proposed amendments would follow away that you've suggested to that part one. It would revert to what was there previously. It would revert back to what you had previously, so instead of having safer site investigations,
Correct.
that would go back to what it was before. Have you spoken to SEPA about condition 15? Has that been part of your discussion, or was it just limited to that other condition?
No, we haven't, not about condition 15. We've reacted to your point, condition 15, by recognising that the words are a bit loose, taking account of, hence the idea of submitting instead following the principles of, if that's better.
Mr. Bloom, do you have any comment on that, on the change of wording?
I'm struggling a wee bit because of the multiple documents and the flicking between the two, just to look at my notes, but I don't have a particular issue with what they've suggested.
Really, it's taking account of which we felt was a bit loose, and following the principles, so it means it feels like a stronger attachment to what's already come through as part of the application. Mr. Smart, do you have any comments on that change of wording?
Is a change of wording which states that there should be adherence to? Is that correct?
SEPA we're looking for should be adherence to, an applicant is set out in that first paragraph the reasons why you may not want strict adherence to, but recognising that whilst it needs some flexibility, taken account of was perhaps too flexible, but by having the wording of following the principles of, and the fact that it's approved by the planning authority in conjunction with SEPA, that's the two kind of layers of protection. One is following the principles of something we've seen, which is the outline CMP, and then it's approval of the planning authority in consultation with SEPA. So whilst it's not strictly in adherence with, it's got those two layers of protection and involves SEPA in that approval process.
Okay, no, I'm fine with that. Thank you.
Okay, with condition 19, the question that we had was for Mr Kelly, but understanding that you are just viewing that, if you want to make comments on this in your closing submissions, we would accept that. So if we move on to then condition 20, abnormal loads. And just being clear on what's being proposed is reinstating the trial run in part 1, removing it from 1G, but should it not still be kept or retained under 4?
Until 4 is superfluous, it can come out.
But is this not just making sure that the trial runs are undertaken in accordance with what's approved?
Yeah, I suppose this is
So you're putting them back in at 1, including proposed trial runs. Like, I see that if you put that bit back in, yes, 4 does seem to be superfluous. In relation to part 3 and this maintaining works in an adopted road, I guess the mitigation measures may not be actual works. It's maybe the wording isn't great, maintain such measures, but I guess if you've got a suite of measures, whatever, like signage or fencing, I don't know what it might be, I guess the expectation would be that those measures would be in place for the period of abnormal load deliveries, which is all I think it's trying to say. But I understand your point about maintaining works in adopted roads, unless you've got some kind of consent on the Road Scotland Act. But I think it's to ensure that when the mitigation works are there for as long as need to be for abnormal loads.
I think amending the wording so the mitigation works are in place, provided those works are related only to abnormal load deliveries, but they would be, wouldn't they, because of paragraph 1b. So that's okay. Sorry.
keep that in because it relates to B.
We can't maintain. We can not move loads until mitigation works are in place.
Yeah.
That's all we can do. Okay. Yeah. No, I think if paragraph 3 is amended so that no abnormal load movement shall take place until the mitigation work set out in the scheme approved under Part 1 are in place.
And I think the next bit's designed to make sure they're not removed. And that's all it's designed to do, albeit I accept that maintaining such measures. But it kind of comes back to what the measures are. If you're thinking it's physical works, then I can appreciate you're not the Adopted Roads Authority.
Yeah.
But it's simply some signage.
Well,
we want you to undo the mitigation measures until after you finish your normal load deliveries. So it's, I don't know if the council have got a view on this and the wording of it.
Maybe just stay retained rather than maintained to maybe solve your concern. I'm not sure if that is your concern.
we can promise not to take them away, but that's about all we can do. We can't stop other people taking them away, and we can't maintain them ourselves. They're in the public highway, so I think there's a point to which we can go no further.
Thank you. If we move on to condition 21, the Habitat Management and Monitoring Plan, again, there's comments and suggested changes. Have you any further comments to add to this at the moment? Thank you. Mr. Whelan, any views on this? Are the changes acceptable?
Just check my notes. Just. No further comments, that's fine.
Okay, thank you. Condition 23, looking to the bird protection plan. Again, changes that have been made. One question that I had was in relation to the deletion of the breeding bird protection plan in reference to it being covered by an all year round bird protection plan. The position of Nature Scotland relating to the breeding bird protection plan was that they considered that as proposed enhancement. So is what's being proposed in the condition now still sufficient to be considered as a proposed enhancement?
I think you're going to have to repeat that point. Sorry, it's late in the afternoon. But I've lost that one completely.
That's okay. In their consultation responses, the ECU, Nature Scot had identified the addition of the breeding bird protection plan as one of the proposed enhancements of the scheme. So if the condition that would secure a breeding bird protection plan is deleted, and you're suggesting that it would actually be covered by a bird protection plan, is that enough? Is that sufficient to still cover the proposed enhancement that Nature Scot had identified from the breeding bird protection plan? It's part of the consideration of what's mitigation and what's proposed enhancement.
Can't answer that this afternoon. I can ask for that week to come back to you on that point. We'll think about it.
And just in terms of the other proposed changes to that condition. Can I just ask if the other parties were agreeable to that, Mr. Whelan?
Yeah, sorry, this isn't really the question you still want to ask, but I had in my notes that should the proposed Golden Eagle regional management plan be secured by Section 75 agreement, is that still to be discussed or as part of this condition? So essentially the Council's approach to that has always been through suspensive condition, and in this case the applicant has volunteered that within their application in the EIA, so they've made a commitment to deliver that. Our view is that a condition is sufficient. Is consistent with the approach taken for the Central Highlands area, which is the Natural Heritage Zone 10. In our report of handling at para 7.166, we suggested there's a suggested condition for a different wind farm development, which effectively says the bird protection plan's measures shall include measures to contribute towards the establishment, adoption and delivery of a Golden Eagle Regional Management Plan for Natural Heritage Zone 7. So I've paraphrased that. That was based on Crathade 2 and the appeal decision that was taken for Natural Heritage Zone 10, but it's the same approach to be taken for 7. Effectively, we need to agree a mechanism for the preparation and implementation and delivery of that protection plan.
And I think what is proposed is it'll be part of the habitat management plan that will take account of commitments contained in the outline regional eagle conservation management plan. So it is being secured by a suspensive condition, but it's part of the habitat management and monitoring plan.
I think it's providing the specific reference to the preparation of the Regional Eagle Management Plan within the condition wording. That would be beneficial rather than just a reference to the Habitat Management Plan for clarity of tracking for our purposes to see which schemes are actually contributing towards eagle management and which schemes are not.
It is specifically part of the wording now of condition 21.
Perfect.
If that works. Again, the applicant, subject to what the council thinks, may want to think about the wording shall take account of in the context of that new part of the condition. But if the council, you're happy that it's part of it, it's a suspensive condition 21.2. It was Mr. Kelly's comment in relation to it being secured by a Section 75 agreement. Obviously, unfortunately, Mr. Kelly can't take part this afternoon. Hopefully he's listening to this and maybe he can respond to the conditions when you put the final set.
That's fine, ma'am. I mean, we've put our comments on the condition as opposed to Section 75 very carefully in the right column, so you can respond to that.
What you have, and the council's explained their position is they would go with a suspensive condition too, so he'll have heard that hopefully and can comment on that.
Yeah.
You have.
Thank you. Moving on to condition 24, peat and carbon-rich soils. There's a slight change, I think, if you've referred to in this with regards to reference to figure 4.1 at 2C. And the question with that and these changes is really to Mr. Smart, Glen Community Council, do these changes address the concerns or help to address some of the concerns that you have with regard to peat and carbon-rich soils?
In some way it does, but our concerns are, from what I've been involved with the blade extension, is that the choice of contractor really is important. I don't know if that can be put into the conditions somehow, and that you need to use contractors that have a record of being able to do construction in this environment and handle the peat. And also it's important that the operators know what they're doing as well. It was blatantly obvious in the blade extension that they didn't. I think SSE took note of that as well in my discussions with them at the end. They admitted that they could have done better there by with the people involved. How do they propose to safeguard in the conditions that happens, that we get competent contractors and operators?
Point taken. That's where we have condition 14, an environmental clerk of works to supervise those contractors.
Will they have the powers and some input to the choice of contractor? What powers will they have to stop? Because if something is going wrong, then it's virtually too late. How do we make sure by test that the appointment of the contractor is the contractor that can actually do this job effectively and protect the excavation of the peat as necessary?
The environmental clerk of works under condition 10, his terms of appointment will impose a duty on him or her to monitor compliance with the relevant environmental, I'm not going to read it all out, but the environmental commitments in the EIA report, the construction environment management plan, the peat management plan, the habitat management plan, and other plans approved under other conditions, to provide training to the contractors and their responsibilities, to ensure their work is carried out in strict accordance with environmental protection requirements, to require the environmental clerk of works to report to the nominated construction project manager any incidences of non-compliance with works which are his responsibility, to maintain a register of all inspections and audits. A monthly report has to be submitted to the planning authority as well as to the developer, and have a schedule detailing when he will be on site, which is required to be as a minimum for the period from the commencement of development until the date of commissioning. I think that's going some way, I hope, to give you some assurance. We'll never give 100%. Can't promise that. We can do what we can.
Thank you for that. I understand that. And yes, there are safeguards there, and hopefully they work.
I hope so. Yeah.
Thank you. Mr. Whelan, can I just ask the councils, have you got any comments on those amendments on that policy or condition?
Yeah, if I'm looking at 24 and his 2 part C, it says the use of floating track as appropriate following site and ground investigations. And then in the commentary, in the notes on the right hand side, it says that the use of floating track will be subject to further assessment. Essentially, we're yet to make a final decision if it's going to be floating track or versus cut track. And for a lot of wind farms in Ireland, we see lots of sections saying it's going to be floating track. The contractors go in and they cut the tracks. And there isn't that safeguard in place. And I think as appropriate in the wording that's been put forward at Part 2C, allows them to make, the contractor can essentially make their mind up of what's going to be easier and more effective for them to deliver it on site. I'm a bit concerned with that wording, and if it's floating track in the EIA, that's what should be delivered. should have done the assessment work to specify what areas are going to be floated and which areas are not. Depends what 15 says. Yeah, do you want to read that specific section at 15 so we can...
Yeah, sure.
My concern is a very long list of details to be checked, to be approved, and would it not make sense to keep it all under the PMP condition?
Oh, sorry.
There's also part Q of condition 15, requiring construction method statements for all roads, tracks to be ordered form within the development, etc., etc. So there's that part of the SEMP as well. And we've got the environmental clerk of works who's supposed to supervise it. So again, we can't achieve perfection, but that's as far as we can go.
I'd just be much more comfortable if it was kept within 24, and then we, as authority, consult SEPA on that detail of that condition, so they'll specifically look at that. If we consult them generally on the provisions of the totality of 15, it can easily be missed in the bulk of material that's submitted, which is a lot of standard method statements.
Peter, are you arguing for the retention of the reference to 4.1, or simply saying you would like this topic addressed under this condition, as opposed to the SEMP?
I would prefer to get it addressed under this condition.
Perfectly happy, in fact, with that, and we can do some work on the wording, circulate it to the council, and come back within a week.
Just on the reference figure 4.1, I do get the point that until you do more site investigation, you can't make a final determination of what should be floating or cut track. But I suppose from a worst case, from say the County Council's perspective, figure 4.1, I suppose gives an indicative view as to the extent of floating track, the extent of cut track. What if that was materially different? When there's been an expectation of the amount, because it does show quite clearly the elements of floating track, fixed track. And I suppose SEPA has commented on the proposal based on that 4.1 with an expectation of the amount of cut and floating track. And whilst I do have sympathy with the fact you need to do your site investigations to finally determine that, I suppose it's that protection to make sure it's within some kind of realms that it reflects what's on figure 4.1 and it's not materially different to that, which could have different impacts.
A very valid point that in fact the the entirety of the PMP needs to be looked at as a whole. That the PMP look at A, B, C, D, E and F. The whole lot has to be submitted to the planning authority, who will consult with SEPA, who will decide whether there's enough floating track, too much floating track, etc. I think that decision is best left to that stage rather than trying to secure adherence to a figure in the EIAR.
Okay, and that would probably weight to your suggestion that this condition does everything it needs to do in relation to the tracks, as opposed to going through this condition and condition 15. So that would probably make sense, given that the need for SEPA to be consulted.
Can I just make sure that there is still reference to floating track in the condition? So there's an expectation, okay, that you don't know precisely how long, if it's going to effectively work, but at least commit to say there is going to be floating track as part of the design. Because there's no reason why there should be no floating track whatsoever.
And as worded, it does say the PMP shall, it says use of floating, maybe just funny wording there, use of floating tracks as appropriate following site and ground investigation. So I think envisaged there would be floating track, and that would be dealt with in the PMP, which would require to come to you for approval with consultation from SEPA.
I'm just struggling with as appropriate, as you know, effectively they could say, well, there isn't going to be any floating track because it's not appropriate.
Well, if that's the view of SEPA, then I doubt it will be, but I can't. SEPA will advise and you will decide.
Okay, I think we'll move on. Yeah, condition 29, aviation, other lighting. The question really it is to do with the ADLS and it's to the council. Can you confirm, is your position that without ADLS, the significant adverse aviation lighting impacts would remain?
Correct.
To be fair, on the evidence on wild campers and occasional lookers at stars at one viewpoint, that's the evidence of Mr. Daly.
I can maybe supplement that with my own site visit, if that helps.
Not giving evidence.
So your the evidence is that it's significant from one viewpoint, as we've said. That was the evidence this morning.
That's what I concur
and
with.
in the other viewpoints, it was not significant. The wording is this test of whether it's reasonable to require the installation of something if it's not financially feasible to do so. Now the applicant is accepting this condition. You know, they think there's no significant impacts from aviation lighting, and this is an obligation, I suppose, in their view, to go a bit further to look at this as a mitigation measure during the lifetime of the scheme. But saying that if, in looking at the feasibility of it, it's financially not feasible, they wouldn't be obliged to install it.
I think the applicant agreed that there was significant lighting effect.
I can't remember, but we're talking about the wording of the condition now.
Certainly that's the evidence that Mr. Day gave today, that he felt the applicant agreed that there was a significant effect from
viewpoint 2.
Viewpoint 2.
Yes.
So my point is, we're in agreement there's going to be a significant impact.
No, I didn't say that.
Let's not go into evidence because we're not on the landscape.
It is set out in my inquiry report.
That's okay, but we're not in the landscape visual impact session. I don't want to get into that need for. I suppose the point is, if this condition is in and consent is granted, is the council still adverse to the words technically and financially feasible, given the extent of the impact?
I would argue, now I don't know if it's been argued before in other wind farm cases or not, that financial viability and cost is the first condition I've ever seen that deals with cost in terms of mitigation. Now, usually if you're a housing developer, you require developer contributions, you have open book valuations done, and you can see they can justify less payments. In this case, say the ADLS is rolled out universally across the UK and it's introduced in maybe it's 5 years' time, this development might not be built yet. They could still build it out and say, well, no, we can't actually afford to install any lights. Radar-activated lighting system is too expensive. Or they might say that down the line in year 10 or 15 or whatever point that is. My point is, the cost of it should be budgeted for from the outset as part of the development cost. And therefore the mitigation should be introduced at the earliest possible opportunity to do so. And it shouldn't be the case that there's a set point in time that actually it's not viable because we paid our shareholders at a certain point and now there's no money left in the project to afford to install the lighting. It's an arbitrary point in time. It should be costed for from the outset, and the condition should not make reference to cost, is my opinion. And if it does make reference to cost, there should either be a viability assessment sort of requirement to be done from the outset, and if it's demonstrated to be viable with lighting mitigation, that could be secured by way of bond.
On the condition, the ECU wording does say taking into account installation and operation costs. So the ECU obviously have a recognition that that is a factor when looking at a scheme. My understanding is that, and I may be wrong on this, so someone can correct me, that there's not sufficient information just now to have an allocation of money somewhere to say that's what it's going to cost.
It's getting trialled at the moment, though, so there's an indication of how much the trial must have cost. There must be.
Nobody knows what ADLS will look like when and if finally approved by CAA. It may involve the provision of primary radar. It could involve the provision of secondary radar. We do not know the costs. We cannot cost it. It could be financially unviable. We don't know. That's why we're offering the condition as it is. The ECU have recognised the need to take account of cost. Full stop.
Could I advocate for, prior to development commencement, that position is at least reviewed? If it is then introduced through more modern consents that technology has been rolled out, that we have a chance to review that prior to commencement.
That is a fair point, and I think it's accepted that if you want to introduce, if you like, a pre-commencement review, after all, we're offering it at the 3rd anniversary anyway. That's perfectly fair.
So can you?
Okay, thanks.
I think that's helpful. If you can build that into the next iteration, that would be helpful.
I've actually seen that imposed before, pre-commencement review, so yeah.
Thank you. The second element of that condition that we had a comment on was about the suggestion by the MOD and structures of 15.2 metres more in height, and the applicant is suggesting a new condition that responds to the MOD's submission. Have you got any further comments on that, Mr. Trinick?
It seems sensible to separate it out.
And Mr. Whelan?
Yeah, that's fine.
Okay. Condition 31, reference to the site inspection strategy. This is to the council. Are you accepting the comments that they have made? This was as a consent and sought for 35 years as the condition actually required.
This issue came up with the last inquiry that was held, I think, for Coolidge Wind Farm as well, that the model condition specifies the requirement for the condition for any consent for 40 years or longer. And in this case, it's a 35-year consent they've applied for. However, the condition wording states that the inspection must take place at year 25. So why would the model condition specify it would only be applicable for a longer duration than the wording? There's a conflict there between the model conditions trigger point. So our position as a council is that that condition should be applied to any consent in excess of 25 years, and it's unclear why the ECU have set this at 40 years. It's contradictory to the content of the model condition.
I can't speak to the ECU's logic. I know what the ECU has recommended. We would rather not have the condition because our consent is for under 40 years. I can't add any more because I can't add to the logic of what the ECU say. I don't know. But
No, I think I understand both your positions on it.
Thank you.
Okay, thank you. With condition 35, we have had a lot of discussion about maximising socio-economic benefit and local benefits. It's just one question, and preferably a short answer if that's possible. To the council, do you consider that condition 35, the local employment scheme, that is the only way that socio-economic benefits could be maximised?
I can't look into the future, but that's the approach the council is taking universally across renewable energy projects in Highland.
Can I ask if you've put this condition onto any peak plan permissions for wind farms?
I believe the condition's on for Traffig Wind Farm.
Which, of course, did not go through an inquiry. That was, yeah. If it helps just to short circuit this to some extent, this is a point which I think Mr. Finlay and I will need to address in closing submissions, because there are legal points to be made, but this time in the afternoon I haven't got the energy to go through them.
There are legal points. We've got Mr. Finlay's opinion on it, your legal opinion, as evidence.
As I understand it, I mean, it may help to just clear some ground out of the way. My understanding is that, certainly from the Coolidge inquiry, Mr. Trinick does not dispute the legality, that it's a possibly legal condition. The dispute between the parties lies as to whether it meets the tests in the circular, and that's a matter upon which we can make submissions. And the tests within the circular of 1998 doesn't require it to be, i.e. if you don't have a condition, the permission would be refused, but in such circumstances there's specific justification for a condition, and our submissions will be relating to the commitments that the applicant has made towards a form of condition, albeit not necessarily in the council's wording, which deals with such issues in fairly well all its documents on socio-economic benefits, and the only way to secure those benefits that is offered will be by condition, because no other way is being proposed. I outline that now because if I've misunderstood the position, obviously I'd like to know before I put in our closing submissions, but that's the basis on which I think where the battleground lies between the parties.
Yeah, I think it's pretty accurate. It will be about the 6 tests, specifically necessity and possibility and reasonableness. That's where the where the argument will be. There are procurement issues, big procurement issues, in agreeing to this sort of condition, and I will outline those issues in closing submissions.
And I think in response to your question that Mr. Whelan answered, there is an extant decision, albeit I'm challenging it on other grounds, WIN-270, where a condition was imposed to deal with local employment, which is in different terms than that. Here, the WIN-270 appeal involves definition of project, has nothing to do with local employment condition, but there is a local employment condition imposed on that. That was a reporter's decision rather than a minister's decision due to the scale of the wind farm. And we can provide a copy of that to you if that would be of assistance. Certainly not. I mean, the report's publicly available.
Yeah, you could provide it as part of your closing submission so the applicant's got a chance to comment if they wish to do so.
Okay, thank you. And the final condition that we had on the agenda was to do with the community liaison group, and it was just your comments or your thoughts, Mr. Smart, on the proposed alternative wording that had been agreed by the applicant and the council. So that's not changed since the 4th of November conditions version, but it's still in that document that was circulated yesterday.
Is this the wording? This is the alternative wording I'm seeing in front of me, is it? Yeah. No, we're agreeable with that. It's refreshing to see that the reasoning as well. So, yeah, we don't have a problem with that. It's fine.
Thank you, and I think that draws to a close the conditions session. Thank you. And that brings this hearing and the inquiry to a close. I'll make my closing remarks. The summaries of case should be provided by parties as part of your closing submissions. And this means the summary of issues in our report will be yours rather than ours. So submissions, the dates for submission will be as set out in the note of the pre-examination meeting, and for confirmation that's the 2nd of December for parties and the 9th of December for the applicant. So Mr. Smart, the closing submissions, these summarise parties' cases, but no new evidence should be introduced or included in them. So it's just summarising what your case is and what you've said here.
Understood, thank you.
Okay, thank you.
Mr. Trinnick, is that timescale okay?
It's never okay, but it'll do.
And on the conditions, are you going to circulate that next week?
Yes, next week, yeah.
So that week today, or is that the 26th? Mr. Finlay, how long would you want to comment on those conditions? And also Mr. Smart.
How long am I allowed? Is there a week suitable?
Yeah, we could be fine. Mr. Smart, you would also get the revised list of conditions. Are you happy to come back with any comments on those within a week?
It'll be submitted to us in a week's time.
Yeah, so it'll be submitted to you 26th of November.
Yeah, I'm away on the 28th and not back till the 5th of December. I can make arrangements before I go for that to be reviewed, if that would help move things on. Otherwise it would need to be after I come back, as I'll be out of the country.
When do you get back, sorry?
5th of December.
Well, on the basis that the applicant's closing submission isn't due till the 9th, we could give you until the 9th of December.
That's okay. Good.
Is that the same date for me then as well?
It would apply to the council as well. And it would apply to Stag. What we'll do is we will issue an email just with these dates in it for everyone, tomorrow from the case officer, just so you have that. Is there anything else that anyone wants to raise at this point?
I'll say thank you for your participation. It's been a long day, but beneficial, I think. Thank you.
I say we're all, I'm sure, all grateful that you sat till 5 o'clock to finish, rather than having us come back tomorrow for half an hour or an hour. Much appreciated for everyone in the room.